And I hope you're having a great day as always. Welcome to Uncivil Law, and we are here with our continuing series of Supreme Court React. For those of you who may not be as familiar with the series, what we do is we pick a case that has been recently argued, and we listen to the oral arguments and we comment along the way. Today is the Affordable Care Act case, which is known as California versus Texas, which was also consolidated with Texas versus California. So let's give you a brief background of how we got to this place and what the issues are that are present in this case now. So as you may remember, the Obama administration got Congress to pass and signed into law the Affordable Care Act, otherwise known as Obamacare. This was a fairly major change to health law for better or worse, and it went into effect. And then a whole bunch of people sued, and the United States Supreme Court in 2012 decided to uphold the Affordable Care Act against the challenge, not on the Commerce Clause issue, which was the issue that Congress actually passed it on and said, we're trying to do this under the Commerce Clause. The Supreme Court said there is a limit to the Commerce Clause, thank God. It's not exactly the first time that there's been a limit to the Commerce Clause. I think the first time ever where the Supreme Court said there was a limit to the Commerce Clause was a case called Prince versus United States. But in either case, it's a relatively rare phenomenon. And they said, being ordered to buy something is not commerce. So not selling something is commerce, but refusing to buy something is not commerce. So there was a limit after all. And then Justice Roberts, writing the majority opinion, famously and very controversially decided it was a tax instead. And I have to say that I was actually in the room when he announced those words. Yes, yours truly. I was in the Supreme Court chamber, and I was listening to Justice Roberts in person as he announced this from the bench. Very exciting. It was one of the perks of living in D.C. and also one of the perks of being a member of the Supreme Court bar and getting preferential seating assignments. Yee. So you can do shit like that. It's really cool. Anyway, so I was in the room when that happened. And so you may remember that initially it was reported that Justice Roberts has struck down the Affordable Care Act. And you may or may not remember that CNN and like everyone else for like the first 10 minutes were saying that Roberts struck down the Affordable Care Act because they couldn't be bothered to read. They couldn't be bothered to read far enough into the page. So that was kind of hilarious. For 10 minutes where CNN was basically saying, oh, it's struck down. And then they're like, oh no, we actually got to page 3 and it says some other things. All right, so I'll tell you my experience of being in the room. Since I didn't get to watch CNN as they were screwing this up live, I couldn't be watching CNN screw it up live because I was too busy watching Justice Roberts live in person. It was pretty awesome. So I'll tell you my experience of being in the room when this happened. So Justice Roberts is giving his oral announcement from the bench, and he's going into this. He's explaining why it doesn't survive under the Affordable Care Act doesn't survive under Commerce Clause. So he's explaining this. And then he basically gets to this transition word. And I forget exactly what it was. It was something like, however, under the taxing authority, blah, 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 where he transitioned this out. And it was a very interesting experience being in the room. The Supreme Court chamber is small. And everyone sits on individual, well, I don't know about everyone, but the bar members at least sit on individual chairs. Yeah, there are benches for other people, but the bar members actually get chairs. Not that they're any good. They're like old wooden chairs. So I was sitting on a wooden chair. I think it was in the second row. I was in the second row. I was about maybe 15 feet away from the Chief Justice as he was saying these things. And of course, everyone's already quiet anyway, because you have to be quiet as they're speaking. But the thing that I heard in the room was when he did that transition and he moved into that however phrase, like everyone stopped moving because people are moving around in their seat. People are moving around in their chairs. And you don't normally think about it, right? It's not something you would normally think about, that you would hear that, people's fabric moving, the cloth of them moving. You would hear like the creak of something moving. You would hear like fabric moving against fabric. You would hear that audibly, and you wouldn't normally think about it because it's so low in the register, right? It's quiet. But when he got to that however period, it became even quieter. It became quieter. Like everyone stopped moving. Everyone froze in place. It was very weird to hear it audibly. And I don't know how many people observed that, but I sure did. Because you no longer heard those background movements. Like everyone just sat up in their chair and straightened up and no one was moving. It was so quiet. You could hear a pin drop as he was announcing it from the bench. It was a very cool experience to be there in the room. And I'm happy to share that memory with you because it's a fond one. Anyways, so he struck it down. So he upheld it under the taxing authority, which was very, very controversial. All right, so let's move forward in time. The United States House of Representatives passed an amendment to the Affordable Care Act that lowered the penalty for not getting health care to zero. So they zeroed out the penalty. So there's still a penalty, I guess, technically. It's just that it's a penalty of $0. So it's like not a penalty at all. And so the basis for upholding the Affordable Care Act in the first place was this penalty or this tax, depending on your frame of reference, right? So is a tax of zero still a tax? Would be one way of phrasing this, right? So Texas sued saying a tax of zero is no longer a tax. You can't call it a tax and then have it be $0. That doesn't make any sense. And so they sued on that. And so that's where the U.S. Supreme Court is picking up the picture. So we got a couple different issues that are populating in place now. We've got the issue dealing with whether or not zeroing it out changes the constitutional analysis from the early Affordable Care Act case. Does it change the constitutional analysis because this fact has changed? So it used to be non-zero, now it's zero. Does that fact change the legal analysis? If so, is the section dealing with the taxing authority severable from the rest of the statute? And then you have to ask, which presumably, yes, it is. But even if it is, then what is the rest of the Affordable Care Act standing on at that point? So severability doesn't really quite answer the question for me, because even if you say it's severable, the rest of the act has to stand on something. And what's it standing on? I don't know. And then there's also the unspoken question of standing, whether or not anyone can sue. Because in order to be able to sue, you have to have a case or controversy. You have to have a harm that is remediable by a court. There has to be an injury to you to be able to sue. There has to be some kind of injury, some kind of harm in order for you to have standing. And so there is a very credible argument at this point that even assuming it's unconstitutional, no one can actually raise that issue at the U.S. Supreme Court because no one is being harmed by the statute, because you can choose not to buy healthcare and you're not going to be harmed. So there's no injury for a decision not to buy healthcare. And so as a result, there being no injury, there's no case. And because there's no case, the Supreme Court doesn't do hypotheticals. So there's a pretty good argument to be had that there's no standing because there is no actual harm. I thought the Fifth Circuit Court of Appeals, the court below, did a very good job of explaining why they thought there were standing. I explained it as well on my own channel. We covered the Fifth Circuit Court of Appeals case whenever that was. We covered that many moons ago. And at least I personally found the Fifth Circuit's argument on standing to be fairly convincing. I found it to be persuasive, but I think it is by no means a lock. I think you can absolutely go the other way. I thought the Fifth Circuit made a pretty good argument for why there should be standing and why you should be able to sue, and assuming that you can sue, then why the law would be stricken down. I thought the Fifth Circuit got a pretty good analysis, but I can definitely see the standing issue going the other way. And if you're looking for an excuse as the court, if you're looking as an excuse of the court to not strike down the Affordable Care Act because you don't want to deal with whatever political ramifications there are, standing is a pretty good way to do it. It's not illegitimate. It's not an illegitimate reason. I think the Fifth Circuit did a pretty good job establishing standing, but I think the other argument also makes sense. So I think a decision saying that there's no standing would also be legitimate, just like I thought the decision to say there was standing was legitimate. I think both are legitimate legal conclusions. And of course, the Supreme Court is the big dog in the room, so their conclusion is the most legitimate, definitionally. So we have to figure out what they think. And if they're looking for a reason to uphold the Affordable Care Act and not get involved, standing is a pretty good way to go. So it's like, we don't have to answer that question because none of you guys had the right to sue at all, ever. The entire case is void from square one. It never happened. You know, that kind of thing. Anyways, let us begin with the oral arguments. Now, one will take note that Justice Barrett is not pictured. It is very sad. We can only assume that her official photo has not actually been taken yet. So Justice Barrett is participating in this. She has been a little bit shafted by being left off the banner here. She would be, of course, on the extreme right of this because that's the seating order. So this is the correct seating order. It's just Justice Barrett over here is not pictured. So that's sad for her. But we'll hear what she had to say. In this 2-hour-long oral argument, which means we'll be here for 3.5, 4 hours by the time we get done. So hope you have nothing better to do. Let's get started with this.
We will hear argument this morning in case 19-840, California versus Texas, and the consolidated case. General Mongan.
Mr. Chief Justice, and may it please the court. In NFIB, this court construed Section 5000A of the Affordable Care Act to create a choice. Either obtain the health insurance addressed in Sub A or pay the tax described in Sub B. In 2017, Congress didn't change Sub A or Sub B. It just reduced the amount of the tax to zero. 5000A still presents a choice. Either buy insurance or do nothing. That inoperative provision doesn't harm anyone, and it doesn't violate the Constitution. Now, respondents insist that the 2017 amendment requires the court to tear down the entire ACA, but that theory rests on two untenable arguments. First, respondents contend that Congress transformed Sub A into a command when it zeroed out the tax. That reading is contrary to this court's construction of the same text. It's at odds with how Congress and the President understood the amendment, and it would attribute to Congress an intent to do exactly what this court said would be unconstitutional. Second, respondents argue that if this single provision is now unconstitutional, then every other provision of the Act must also fall. But the starting point of any remedial analysis would be the strong presumption in favor of severability, and here the text and statutory structure powerfully confirm that presumption. After a year of debate about the future of the ACA, Congress made a single surgical change. It made 5000A unenforceable by eliminating the only legal consequence for not buying insurance, and it kept every other provision in place. So we know the rest of the Act should remain in effect if 5000A is held to be unenforceable, because that's the very framework Congress itself has already created. Mr. Chief Justice, I welcome the court's question.
I don't really buy the end of that argument from California. It was doing okay right up into the end, but I don't really buy this argument. It's like, well, we know it should remain in effect because Congress considered all these issues and it passed a law dealing with this, and so that's what Congress wants. That argument doesn't really work for me because that's kind of true of just every act of Congress, period. It's like, oh, is there an act of Congress somewhere where Congress isn't at least theoretically thinking about the issues and trying to pass constitutional laws? And the Supreme Court strikes down laws fairly often. I think, well, it's not that frequently. It's like one, I forget the exact number. I think it's like two. It's a little bit more than two a year on average. It's like 2.2 times a year the Supreme Court actually strikes down statutes. So it's not extremely common, but yeah. So it's like, well, Congress just changed this one section, and because then changed everything else. So of course the entire law is constitutional. I don't buy that argument. That doesn't really work for me.
Thank you, General Mongan. I'd like to begin with the standing issues. Is someone who does not follow the mandate and purchase insurance violating the law?
Not on our view, Your Honor. We think that this is an operative provision and there is no legal command. But even if the court were to accept the plaintiff's theory that it is a command at the standing stage, they still can't establish standing because there's no threat or even any possibility that that command would be enforced against them.
Well, so if someone who doesn't purchase insurance pursuant to the mandate applies for a job down the road and has to fill out a questionnaire asking whether you've ever violated a law, which box should he check, yes or no?
Well, I think if their view, Your Honor, is that this is a command, I suppose they'd have to say that they violated the law. And if they had alleged that they were applying for such a job and that the employer was going to use such a form, then that might be a viable theory of standing. But of course, there's no such allegation before us here today.
Well, let's say Congress passes a law saying everybody has to mow their lawn once a week. And they even make a lot of findings about why that's a good thing. You know, it makes the country look neater. You get fresh air if you have to do that. Supports the lawnmower business. But the fine for violating it is $0. Do they have standing? I mean, the neighbors will see that they're not obeying the law. The objectives of Congress will not be fulfilled. In other words, there'll certainly be injury to that person, and I wonder if under your theory that person would not be able to challenge the law.
I don't think that they would be on the theory that they've altered their conduct to comply with the law and they've suffered some injury. I think that follows from this court's cases in Poe and Holder and American Booksellers, that it's not enough to say that I'm injured by complying with the law. You also have to show some real threat of enforcement. And here, of course, Congress eliminated the only enforcement mechanism in 5000A.
Thank you, General. Justice Thomas?
Thank you, Mr. Chief Justice. General Mongan, in putting it the Chief Justice's question in today's terms, I assume that in most places there is no penalty for wearing a face mask or a mask during COVID. But there is some degree of opprobrium if one does not wear it in certain settings. What if someone violates that command? Let's say it's in similar terms to the mandate here, but no penalty. Would they have standing to challenge the mandate to wear a mask?
Well, Your Honor, I think under this court's cases, the question comes down to whether there is a real threat of enforcement. If it's just a bare command, I don't see how that would be consistent with cases like Poe and Holder that have looked not just to the question of whether it's a command, but to whether there is a threat or possibility of enforcement. Now, perhaps
is that consistent with some of our, for example, our First Amendment jurisprudence, where even without a penalty, you could have a chilling effect?
That's a pretty sharp question from Justice Thomas. Not that we should necessarily expect less from Justice Thomas. He is, of course, the most senior. Well, he's the longest serving member of the Supreme Court. I was going to say, well, he's the most senior, and I'm like, no, he's not. Justice Roberts is the most senior. He's the longest serving member of the bench, so we shouldn't expect less. And yeah, that's a pretty good contra. It's like, yeah, there is in the First Amendment example, even where there are not penalties, the courts do get involved in those cases. I think you can distinguish on the First Amendment because, the First Amendment is kind of special. Freedom of speech is considered a paramount value, and the courts will do things in First Amendment arena that they won't do in other situations where they'll do things and get involved and issue orders. So, yeah, you do see occasionally where that happens in a First Amendment context, and this is a good example of that. So it's true in the First Amendment context. I'm hard-pressed to think of where it's true in any other context, and I don't think it's necessarily true here because the First Amendment is treated with the special reverence, and I think that's probably good. So, yeah, just because we occasionally, well, very rarely, to be quite honest about it, but just because very rarely we'll get involved in the First Amendment analysis because of the chilling effect, I don't think it quite holds for the ACA, but, nice try.
Your Honor, I think that there may be other legally cognizable theories of injury beyond the type articulated by the plaintiffs here, which is strictly focused on I'm complying with this command in a way that harms me. And in this case, we're not in the First Amendment realm, but the states have suggested that there might be some theory of harm from the effects of third-party conduct. That might have been a viable theory, but their problem is that they have not established with evidence that's required on summary judgment that the amended 5000A, which is entirely toothless, actually actually does inflict such a harm on them.
The parties here, the respondents here, really, they're arguing that, as we had in the first ACA case, they're arguing that the mandate in combination with the other provisions really caused their injuries. What is curious here is we have become accustomed to deciding this at the standing stage, and this looks somewhat like a statutory, the severability issue looks like a statutory construction matter. So could you explain to me why we would determine severability at the standing stage?
Why you determine severability at the standing stage? I'm not sure I even understand the question. I'm not sure I even understand the question. Determine severability at the standing stage. Like, either you have standing to sue or you not. The law is the law. The law, you can't get to severability until you get to standing. I'm not even sure I understand the question. Play for me. Thank you.
Stage, I suppose it could do that in the process of evaluating the federal government's theory of standing by severability. We don't think that that's a theory that's ever been endorsed by this court, and it seems like it would create some serious tension with this court's Article 3 precedent. But typically, severability would be analyzed after a ruling on the legality of the provision.
So how would you say, you would, I see my time's up. Thank you.
Justice Breyer?
Well, I'll follow up on Justice Thomas's question. How do you respond to the United States theory of standing?
So it's a novel theory. It's never been endorsed by this court. It would create a fairly massive loophole in Article 3 because in the ACA context, for example, any American who's regulated by any provision of the ACA, biosimilars or the menu calorie count provision, would be able to challenge 5000A without showing that that provision actually harmed them. And I do think it's in tension with this court's Article 3 precedent in several respects. First, what the court has indicated in cases like Daimler-Chrysler is that a plaintiff needs to establish standing for each claim, and they need to show that they are injured by the allegedly unlawful conduct or provision. And here we'd be allowing on the government's theory plaintiffs to proceed without doing that. And second, I think it would create a real concern about advisory opinions because as I understand their theory, you'd have to accept that the provision is inseverable at the standing stage, then you'd proceed to adjudicate the legality of the provision, and then after that you'd get to severability. But as we know from AAPC, most provisions are severable, so it would lead to a situation where courts are adjudicating the legality of provisions that don't actually harm the plaintiffs before them.
It would create a real concern about advisory positions because, as I understand their theory, you have to accept that the provision is inseverable at the standing stage. Then you proceed to adjudicate the legality of the provision, and after that you get to severability. But as we know from the AAPC, most provisions are severable. Severability is the standard rule, and usually Congress expresses it explicitly, but it is the standard rule. So it would lead to a situation where courts are adjudicating the legality of provisions that don't actually harm the plans before them. Well, I don't know that it's accepting the provision is inseverable at the standing stage. I don't think that's quite the right frame. I think it's better to say you're accepting the provision as applicable or applicable to you at the standing stage, because that's a necessary premise, right? If the thing is not applicable to you, then you definitely don't have standing. So you'd have to say, well, this law applies to me, as it's written, and then you might get down into the analysis and be like, well, no, actually not so much, because as it turns out, this section is illegal for whatever reason, or it's severable, or any number of reasons. But on its face, you do assume that statutes are valid as the first instance, right? You do assume that statutes are constitutional until they're proven not. There is an assumption that Congress passes constitutional laws. Now, whether or not that assumption should be warranted is a whole nother problem, but it's assumed that they do. So if you come to me as a judge, if I'm a judge and you come to me and you say, this law applies to me, I'm not going to get to inseverability because that's striking down. Or I'm not going to get to severability because to say something is severable, at the start, I'm not going to get to severability. I'll get there eventually. But I'm not going to do it at the start because to say something is severable is to say that part of this law doesn't exist or doesn't apply to you. And that's like cart before the horse. My assumption going in is it does exist. It does apply to you. I have to, at the very, very start, I do assume that all the provisions are valid. And as I go on, I presume they're valid. And then eventually I might get to severability. But to say you shouldn't accept that it's inseverable at the standing stage, it's a strange frame. I would think you would accept it's inseverable at the standing stage, or at least you'd accept that it's applicable and applicable and valid at the standing stage. You wouldn't first analyze the severability question. That's very strange. You just assume the statute is valid as passed, all the elements are valid as passed, and then you go apply them, and then if you run into a problem, you deal with severability later. I don't understand this. This is weird. All right, let's move on.
Thank you. Justice Alito?
Texas has offered evidence that the Affordable Care Act requires it to calculate Medicaid eligibility using modified adjusted gross income, and that this method of calculation has greatly increased the number of persons on Medicaid in Texas, I think by about 100,000 persons. Why can't Texas seek a declaratory judgment that it is not required to calculate eligibility using that method?
Well, I think that the problem is that they need to show that they're injured by the provision that they actually allege is unconstitutional, and that provision that Your Honor referenced is separate from 5000A. It would remain on the books even if 5000A were wiped away. So unless the court were willing to accept the novel theory of standing by inseverability advanced by the federal government, I don't see how Texas's theories about many other provisions of the ACA can establish a case or controversy with respect to this claim challenging amended 5000A.
Well, there is logic to that theory of standing. Why is it conceptually unsound?
Well, we think it's unsound because it then would allow the court, allow a party to come into court and challenge, any aspect of a large statutory scheme by just asserting a theory that it's inseparable from one provision that harms them.
Yeah, no, that's definitely not going to fly. So if that's the U.S.'s position, that doesn't make sense. So if that's the U.S. Government's position, it doesn't make sense. So yeah, if I'm being harmed by some provision of a statute or many provisions of a statute, then my cause of action is under those provisions of the statute. I'm not harmed by other provisions of the statute. To put it into a context that would make sense for me, at least, and not necessarily for the rest of you, but whatever. To put it in context that makes sense for me, because my job is patent law, right? So if the office writes a denial for an invalid thing, well, my harm is in their failure to follow their procedures, APA. My harm is in their misinterpretation of section 101, 102, 103, so forth and so on. So that's like my, by the way, I say 101, 102, 103, not because they're the first three of the sequence, but because they're the three most important. So I realize that could be misunderstood because I say like 101, 102, 103, and then you're just thinking, oh, I'm naming all the sections. No, I'm not naming all the sections. It just so happens that 101, 102, 103 are the most important, and 112, if we want to throw it into the list, just to break up the monotony of it. So 101, 102, 103, 112 would be the most important. Anyways, so it'd be like saying, okay, I've been harmed under the AP. I've been harmed by your interpretation of 101, 102, 103, or 112. And also, by the way, section 127, which has absolutely nothing to do with my case, I'm also upset about, even though it doesn't apply to me. Here's let's talk about section 104 that deals with inventions made in space. And I think that's bad. that doesn't make sense. You can only argue over what you've been harmed other. If there's other sections that are invalid, but they don't apply to you, no.
But, Your Honor, if the court wanted to create that type of rule in its standing jurisprudence, that would just bring us to the merits. And the problem with the merits theory is that the plaintiffs here are positing that Congress created the very command that this court held in NFIB was constitutionally impermissible. And that's just not a plausible construction when you consider that Congress was well aware of this court's statutory construction. It relied on that choice-creating construction and used it to just render the provision inoperative.
Let me ask this related question. If Texas were to fail to use that method, what consequences would follow?
If Texas were to fail to use the method for calculating Medicaid eligibility, Your Honor?
Yes.
I don't know. I suppose it's possible that the federal government could bring some sort of enforcement proceeding against them, or that an individual could sue on the theory that they should be eligible for Medicaid.
Well, I would ask a related question about what would happen if the IRS attempted to assess penalties on state employers for failing to comply with the reporting requirements in sections 6055 and 6056. In a collection proceeding, could the state argue that it has no obligation to follow that because they can't be severed from the individual mandate?
Well, those are separate provisions. I suppose it's possible that a defendant could try and advance that as a defense in response to such a claim, but that doesn't mean that as a plaintiff they can go into court and establish an Article 3 injury tied to 5000A that's sufficient to exercise the court's jurisdiction.
Thank you.
Justice Sotomayor?
Counsel, if I understand, and please tell me if I understand your point correctly, which is if they have claims challenging the provisions that Justice Alito asked about, they should have brought that challenge, not a challenge based on the individual mandate, correct?
That's exactly right, Your Honor, and although they have discussed a lot of the costs that flow from other provisions of the ACA, they haven't directly challenged those provisions, and they haven't advanced any theory as to why those provisions are unconstitutional.
Yeah, I think Justice Sotomayor has it about right here. It's like, yeah, if you've been harmed by some other section of the statute, then bring your lawsuit dealing with the section or sections of the statute you've been harmed by. So you brought a section under the individual mandate, but you haven't been harmed by that section. You haven't suffered any injury. So if you've been suffered by some other section, then like you can deal with that. So yeah, that's a very weird way. You could then you could even deal with the individual mandate as a secondary issue to that. So it's like, I've been harmed by this provision and also it's unconstitutional. But to just come after it's unconstitutional is a very strange frame. So I think Justice Sotomayor has the better reading and better understanding here so far. I'm not sure what it says about anything because Justice Sotomayor is, at least by most metrics, considered to be the most left-leaning member of the court at this point. But, she makes sense. I thought she was right in Kansas v. Glover. So, I don't know. Sometimes she gets it right, I guess, even in spite of the conservatives. So, yeah, I think that makes sense.
Second, counsel, give me your best argument why it would be unreasonable or not legally enforceable for plaintiffs to read the individual mandate as a legal command. You answered Justice Roberts' questions in a hypothetical, but I'm asking, are you accepting that hypothetical or that assumption, not hypothetical, I used the wrong word, assumption, or do you have, what's your best argument that it's not a command?
No, we're not, Your Honor. This court authoritatively construed 5000A and NFIB as not a command. It said it was a choice between buying minimum coverage as set out in sub A or making the alternative tax payment in sub B. That's an authoritative construction that Congress relied on when it amended the provision in 5000A. Congress did not clearly indicate that it wanted to depart from that choice construction. Rather, it relied on the choice construction, zeroed out the tax as a means of making the provision inoperative. And I think this is a critical point, Your Honor. Congress was entitled to rely on this court's authoritative construction, and we ought to give Congress the benefit of the doubt that it was doing what it said it was doing, preserving a lawful choice, rather than imposing the same...
I assume we're going to get into this issue later, but there is a dispute as to what the Affordable Care Act actually held with respect to whether 5000A is a command or not. There's a dispute on the proper reading of what the court actually wrote in NFIB. I think Justice Kagan comes to this later, where she's like, oh, you're misreading the case. So Justice Kagan's like, you're misreading the case. And the attorney's like, no, you're misreading the case. Nuh-uh, uh-huh. Obviously, they've put it in more professional language. But there is a dispute on exactly this point as to whether or not the Supreme Court actually said that 5000E was not a command or not. So we'll get to it later.
Counsel, I have no quarrel with, but why should we presume that a common citizen who wants to comply with the law would make that assumption?
Well,
or should make that assumption legally?
Well, Your Honor, I think that to the extent that a common citizen is considering the intricacies of federal law, they would consider this court's authoritative and very prominent holding about this provision in NFIB. And of course, they would also consider the very public and repeated pronouncements of the President and members of Congress who said, we've gotten rid of the individual mandate, and now you're allowed to freely choose what to do with whether to buy insurance.
One last question. If I understand your standing argument within this involving the states, but are you arguing that the states are not harmed by the cost of more people enrolling in insurance as a legal matter, or is it that as a factual matter you think they have not yet demonstrated that they were harmed?
As a factual matter, Your Honor, we're on summary judgment. It was their burden to introduce specific facts showing that amended 5000A actually drives up their costs. They put in 21 declarations, but they didn't actually address that point.
So how do you deal with their argument that you had the burden of coming forth with evidence?
Well, I just don't think that that's consistent with precedent. It's the plaintiff's burden at summary judgment to establish that they have satisfied the requirements of standing.
Justice Kagan?
General, just continuing on this point of the state standing, I mean, why wouldn't it be right to say something like, look, you can expect that as a result of this law, more people will buy insurance, even when there's no enforcement mechanism. Just the force of law itself will encourage people to buy insurance. And Texas is now saying, well, that costs us money. It costs us money because of its effect on programs like Medicaid, and it costs us money because we have to send out these forms saying that you've bought insurance. I think that those are Texas's two arguments.
Well, Your Honor, we think under this court's precedents in cases like Lujan, that might be enough at the pleading stage, but that it wouldn't be sufficient at the summary judgment stage. But frankly, Your Honor, if we're misreading those cases, we'd be happy to lose on the issue of state standing and litigate this case on the merits, and then have Texas's rather minimal showing here set the bar for state plaintiff standing theories going forward. We just don't think that your cases allow it.
And why is that? What case doesn't allow it?
Well, I think it's just a general principle that a plaintiff must adduce specific facts to establish injury and causation, as the court indicated in Lujan. And that, we would think, would require something more than speculation or supposition.
And how about on the individual plaintiff side? This is going back to the Chief Justice's questions. I mean, why shouldn't the force of law itself, a person can say, if the law says I need to do something, then I have to do something. And we want citizens to be law-abiding. Why isn't that enough to create standing?
Well, I understand that point, Your Honor, but I think that that's contrary to what this court has said in cases like Poe. I mean, there the doctor plaintiff said, I'm looking at this law. It says that I can't give advice to my patient, and I think the law is unconstitutional, and it harms me because I'm not able to give this advice. And the court said, well, that's not enough. You also have to show a real threat of enforcement. So I think that would be a departure from what this court has indicated before, and it might open the door to quite a number of additional pre-enforcement challenges.
Thank you, General.
Justice Gorsuch?
Good morning, counsel. Let me pick up where Justice Kagan left off. As I understand it, the United States could still bring a civil action to enforce the mandate under 26 U.S.C. 7402A. Is that your understanding as well?
That's not my understanding, Your Honor. I think that this court made clear in NFIB that the only legal consequence of not purchasing insurance is the requirement to pay a tax, and Congress has repealed or zeroed out, rather, the tax. So there are no remaining legal consequences, and I just...
Let's just suppose for the moment that you're mistaken, and 7402A would allow a civil enforcement action. Would that change your view about the individual standing?
Potentially, although I think what this court has looked to is not just the possibility of an enforcement action, but whether there is a real threat of enforcement. And here I don't see how they'd establish that because, of course, the federal government has indicated that there's no further requirement for individuals to purchase health insurance, at least at the highest levels of the executive branch. That's the signal that's sent out to the country.
So individual Americans would have to await an enforcement action before bringing a lawsuit challenging a federal statutory command?
Well, that's our understanding of your cases, Your Honor. But again, if we're misreading the standing cases, we're very happy to litigate this question on the merits because we don't think that they have any plausible basis for reading this as a command, and we'd be happy to have the court reach that question either at standing or on the merits.
And then with respect to the states, again, picking up on Justice Kagan's point, I thought I heard you agree that the theory of standing, that there's raised costs on enrollment-based injuries or compliance-based injuries could be enough to secure standing. It's just a failure of proof at the summary judgment stage. Is that a fair summary of your position?
Yes, that follows from Department of Commerce. States can establish standing if the predictable, if they actually identify specific facts showing that predictable choices by third parties are going to drive up state costs. But unlike the census case where we had lots of expert declarations and specific facts and detailed government memoranda showing that connection, Texas here has just not introduced any specific facts indicating that amended 5000A would inflict a concrete harm on the plaintiff state.
So if all we need is a substantial risk of a predictable effect of government action on the decisions of individuals, why isn't the Congressional Budget Office report stating that even after the penalty is removed, a small number of people will enroll because of a willingness to comply with the law? And it follows from that there will be increased costs to the states.
Your Honor, I think this CBO report from 2017 is probably the best thing they have going for them on state standing. We don't think it's sufficiently specific. It's a single sentence, and CBO didn't offer any data backing it up. And
do you disagree with it?
I don't think that we have any basis to agree or disagree with it.
So it's an uncontested fact in the record?
No, I don't believe that's right, Your Honor. It doesn't say anything specific to the plaintiff states, and it doesn't say anything specific to plaintiffs who are eligible for state health plans. So we wouldn't think that that's enough at the summary judgment phase. But again,
Justice Kavanaugh?
Thank you, Mr. Chief Justice, and good morning, General Mongan. To pick up on individual standing questions of the Chief Justice and Justices Kagan and Gorsuch, suppose Congress passed a law requiring every American who lives in a house to fly an American flag in front of the house. There's no penalty, and the question then is individual standing. Under Lujan, you're the object of the regulation as a homeowner. It's a forced acquisition of an unwanted good or service. Why isn't that enough to give you standing, knowing that some people are going to do that, buy the flags and fly them simply because Congress requires that?
Well, Your Honor, I think if their theory was identical to what the individual plaintiffs advance here, simply that, look, we are complying with this and it is causing us harm. That would run into a similar problem with the Poe line of precedent, but there may be some other legally cognizable injury, especially in the First Amendment context. And we're not disputing that plaintiffs can try and advance those types of theories of injury. We just don't think that they're substantiated under the circumstances of this case.
And on the CBO report that Justice Gorsuch mentioned, do you disagree that some people will follow the mandate and purchase insurance solely because of their willingness to comply with the law?
Well, I don't have a basis for disagreeing with it or agreeing with it, Your Honor. I think it is unlikely, as the dissenting judge below noted, that individuals who wouldn't already take advantage of the very generous Medicaid programs or state employer health plans would do it solely because of an unenforceable command. But again, if we're wrong on that, it just brings us to their untenable merits theory that Congress has created a command that this court said was constitutionally impermissible, even as it was telling the American people that it was trying to get rid of or make inoperative this provision.
On the
good answer.
Point that you mentioned that
That's a good answer.
Allowing individual standing here might open the door. Are you aware of any other examples in the U.S. Code, at least, where Congress has enacted a true mandate, not something hortatory, but a true mandate with no penalties?
Your Honor, I'm not aware of that, and we don't think that's what Congress did here. We think that they just...
Yeah, I take that point. I was just wondering if you were aware of an example. On the merits of the claim, under NFIB, obviously it was justified under the taxing clause, but it now doesn't raise revenue. How do you respond to that point?
So in light of the NFIB construction, what Congress did here was to create an inoperative provision. It doesn't require anybody to do anything, and Congress has routinely created inoperative provisions. It's done so since the founding, and they haven't been viewed as constitutionally problematic because they don't alter legal rights or responsibilities or bind anyone.
Thank you.
Justice Barrett?
What should we make of the fact that Congress didn't repeal the provision? I mean, you said earlier repeal, and then you corrected yourself and said zeroed out. I mean, you're asking us to treat it as if it functionally has been repealed, but that's not what Congress did. Does that matter?
Your Honor, I think Congress understood how this court had construed 5000A as a choice, and it understood that it would make the provision effectively inoperative to zero out the tax. And that was a reasonable thing for it to do. Obviously, it was operating under reconciliation procedures. That allowed it to make the change compliant with the Byrd Rule, and CBO had told it that there was no material difference between repealing the provision and zeroing out the tax.
Let me ask you another question that's related to some of the hypotheticals you've heard so far. You know, the Chief asked you about a mandate to mow the lawn, and Justice Thomas asked you one about forcing people to wear a mask. What if, in this case, and as I understand it to be the case, you have to certify whether you've complied or not, and then the government keeps track of that. So the government keeps track of whether you wore a mask or whether you purchased health insurance. Does that change your view of whether there's an injury?
Well, I'm not sure that there is an ongoing certification requirement, at least in the tax forms, Your Honor. Perhaps that would change the analysis. But if we get to the merits, then I think that it's plain that this is not an operative provision and there is no ongoing command. So even if that would establish standing, it wouldn't be enough to allow the individuals to prevail on the merits. And Your Honor, I would like to just make the point that if the court were to disagree with us on the merits and hold that this is a naked command, then the only proper remedy for that would be an order making the provision unenforceable and holding that it's invalid. That would completely address the problem. What would be deeply problematic for the plaintiff, for the petitioner states, and for the rest of the nation is if plaintiffs were allowed to leverage this single inoperative provision to tear down hundreds of other provisions.
Yeah, he's got a good point. So I think he's got really solid good points. So I think California is definitely so far doing very good on their end of the case. So he's pointing out that there is no penalty here. He's pointing out the United States government's theory of standing is problematic. And he's pointing out also that if these people are right that this section is invalid, then the court can just invalidate the section without touching the rest of the statute. And that would be severability. And so, yeah, you could sever it away from anything else. It's like you've been injured by anything else. If you've been injured by any other provision and you're trying to raise your complaint there, then you could deal with the unconstitutionality of the statute. But yeah, I think he's right. So I don't know if this is a problem in how Texas framed this or how they brought the issue to court, but I think he's probably right that, yeah, the United States government's a theory, at least as he explains it, doesn't make any sense. The Texas, by only going after this one statute, said we've been harmed by this. It's like, okay, we'll strike it down. The rest of it you can maintain. Yeah. And also, it doesn't operate because it doesn't do anything, so there's no harm. Yeah. So there's no injury, there's no standing, there's severability, you can remove it out. I think his theory of the case makes a lot more sense so far. All right, let's press on.
Counsel, but let me just return to the question on the merits. So the states have said these forms 1095B and C do require, as part of taxes, for one to certify whether or not one has maintained the minimum coverage necessary. Is that incorrect?
Well, Your Honor, the states do have to send out the forms. Those are required by separate provisions, and they serve continuing purposes related to the premium tax credit and the employer mandate that have nothing to do with 5000A. So those are costs that they would continue to have regardless of whether 5000A were on the books or not.
And individuals don't have to certify whether or not they've maintained coverage?
Well, the IRS website makes clear now that there's no longer an obligation on the annual tax forms to check the box regarding coverage. They've gotten rid of that requirement.
Okay, thank you, counsel.
Minute to wrap up, General.
Thank you. The plain intent of the 2017 amendment was to make 5000A inoperative and unenforceable, not to impose the very command this court said would be unconstitutional. And the current statutory framework makes clear that Congress wanted every other ACA provision to remain in effect if 5000A were unenforceable, because that's the precise situation Congress created. Respondents in severability theory would do violence to Congress's intent, invalidating hundreds of provisions that Congress chose to leave in place and that are functioning perfectly well without an enforceable 5000A. It would cause enormous regulatory disruption, upend the markets, cast 20 million Americans off health insurance during a pandemic, and cost the states tens of billions of dollars during a fiscal crisis. There's no basis for that result in text, intent, or precedent.
Thank you, General. Mr. Verrilli.
Thank you, Mr. Chief Justice, and maybe.
Yeah, so I really like California's argument. I think that they've got a solid, really solid argument that really makes a lot of sense. And yeah, it makes a lot of sense. So I think they have a pretty good argument. So that was the Solicitor General of California who spoke. So now we're going to hear from the Solicitor General of the United States, who's in this really kind of strange position because the United States government didn't participate at the Supreme Court level because they won and didn't want to do cert. So this is weird because the United States House of Representatives has picked up the fight. So technically, at this point, he's arguing on behalf of the U.S. House of Representatives rather than the U.S. government as such. So whatever. But let's listen to the Solicitor General of the United States / the Solicitor General of the House of Representatives. All right, let's see what the U.S. government has to say.
Please the court. Respondents are asking this court to do what Congress refused to do when it voted down repeal of the ACA in 2017. But their argument is untenable. The 2017 Congress did not convert Section 5000A from a choice to a command. The amended statute doesn't require anything of anyone. And even if one misconstrues 5000A as a mandate, it's not plausible that the same Congress that had just eliminated any economic pressure to purchase insurance nevertheless thought that an unenforceable mandate was so vital that its invalidation should doom the remainder of the ACA. There is just no way that Congress would have preferred an outcome that throws 23 million people off their insurance
ends protections for people with pre-existing conditions, and creates chaos in the healthcare sector. Respondents' arguments take constitutional adjudication as a game of gotcha to a whole new level. But this is not a game. This court's precedents require respect for the constitutional role of Congress, and those precedents emphatically foreclose the outcome respondents seek.
Mr. Verrilli, 8 years ago, those defending the mandate emphasized that it was the key to the whole act. Everything turned on getting the money from people forced to buy insurance to cover all the other shortfalls in the expansion of health care. And the briefs here on the other side go over all that. But now the representation is that, oh no, everything's fine without it. Why the bait and switch? And was Congress wrong when it said that the mandate was the key to the whole thing? That we spent all that time talking about broccoli for nothing?
So, Mr. Chief Justice, in 2010, I don't think there's any doubt that Congress made a predictive judgment about what would be needed to create an effective market, and they adopted a carrot and stick approach. And there were a lot of carrots. You know, the policies were attractive, limited copays, no annual or lifetime caps. There were generous subsidies to draw people into the market, and it was easy to enroll because of the exchanges. But there was also a stick, the tax payment if you didn't enroll. And I don't think there's any doubt that the 2010 Congress thought that stick was important. But it's turned out that the carrots work without the stick. That's the judgment that the Congress made in 2017. It's what CBO told Congress, that Congress asked the CBO, what will happen if we repeal the mandate outright? What will happen if we zero out the tax? And CBO came back and said, whether you zero out the tax or you repeal the mandate, the effects on the market will be the same. The market will remain stable over the coming decade. And if one looks at the amicus briefs filed by the health insurance industry, the Blue Cross brief, the AHIP brief, if one looks at the AMA brief, all those briefs are confirming that that judgment was correct, that it turned out that the carrots worked without the stick, brought enough people into the market to allow it to sustain itself. And, you know, Congress is allowed to learn from empirical experience in the world and adjust its policy choices, and that is what happened here.
General Mongan was asked about whether the burden on the state was enough to support standing. And of course, he had a little bit of a conflict representing a state, but you don't. Do you think that that burden is sufficient? The paperwork burden, essentially.
No, Your Honor, I don't, because the paperwork burden flows from provisions other than Section 5000A, and so unless the court were to accept the standing through inseverability theory, I don't think there's a basis for finding standing on the basis of that injury.
Thank you, General. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, Justice Barrett asked whether or not just eliminating the penalty, the act wasn't changed, about the mandate provisions weren't changed, just the penalty was eliminated. So was that all that was necessary to eliminate the centrality of this and importance of this provision? Because when you argue that when this case came up, as the Chief Justice said some years ago, this provision was the heart and soul of the Affordable Care Act. And I know the assessment has changed, but the provision hasn't changed with the exception of the penalty. Could you explain why that penalty provision was so critical to the centrality of this provision?
Well, I think, Your Honor, this does go to the heart of the severability question, and I guess the argument that my friends on the other side are making is that the continued existence of 5000A sub A, even though it's unenforceable and there's no tax anymore, is still central to the operation of the Act, such that under the court's inseverability precedents, Congress would have preferred that the entire Act come down if that provision was struck down. And I think there are 4 reasons why that can't be right. First, you'd have to accept that the 2017 Congress said, we're going to eliminate any financial pressure to stay in the market, but the moral suasion is still so important that the entire law has to fall. And I just don't think that's a plausible account of what happened in 2017. Second, Congress
asked the CBO what would happen if they repealed, what would happen if they zeroed out the tax. And the CBO came back and told Congress the effect on the market will be the same either way. In other words, there will be no material difference between zeroing out the tax and flatly repealing Section 5000A sub A. And that's the context in which Congress acted here. Third, the contemporaneous history is quite clear. The president, the congressional leadership, the bill sponsors, the committee chairman, they all were shouting from the rooftops that they were repealing the mandate and giving citizens complete flexibility about whether to purchase insurance. That is not what you would be saying to the world if you thought that moral suasion was essential to keep the system going. And finally, even if you thought that Congress really did have an interest in continuing moral suasion, that doesn't mean that they would have preferred to bring the whole ACA crashing down if 5000A were declared unconstitutional. In that respect, I think it's a lot like Celia law. There, in contrast to here, you had actual evidence that Congress wanted the CFPB director to be independent of the president, and that was here was just a hypothesis. There was evidence, but the court made the judgment there that Congress would not have preferred to see the entire CFPB come crashing down if that independence were eliminated. And I think that same kind of reasoning applies very strongly here.
Thank you. Justice Breyer, can you hear me?
Justice Breyer?
Yeah.
Thank you, Justice Breyer.
Yeah, I'm connected, I think. Question about the severability. Since at the time we heard, when this was first passed, that the mandate was absolutely crucial, as you pointed out, because unless people buy insurance under this mandate, the other provisions, such as you don't have to worry about pre-existing conditions, etc., won't work. All right. Why isn't that fact?
I'm sorry, Justice Alito?
Something happened. I'm sorry, my machine didn't work.
Yeah, I thought Justice Breyer was still on his time.
No, Justice Alito?
Oh, all right. Well, thank you.
So we are all mutually spared the question to nowhere from Justice Breyer, thanks to technology. So the hero of today is the phone system for whatever Justice Breyer is using, because he wasn't allowed to ask his question. Ah, man. All right, let's move on to Alito.
Mr. Verrilli, this does seem like deja vu all over again. But let me ask you this question about the theory of standing by severability. Suppose there's a very simple statute. It has two provisions, A and B. I am hurt by B. I am not hurt by A. A is unconstitutional. The statute has a clause that says if A falls, B falls too. Under those circumstances, would I lack standing to challenge A?
Well, that hypothetical definitely tests the limits of our objection to standing through inseverability, and I think it would be hard to maintain that position in the face of a statute like that. But what I will say, Your Honor, is this, that what it does point up, I think, is that if the court is going to validate the theory of standing through inseverability for the first time, that it ought not to do so combined with a presumption of inseverability at the standing stage, because even the situations like the one Your Honor's hypothetical describes are going to be very rare. And most of the time, as the plurality opinion in AAPC acknowledged, severability will be the outcome. And so if one presumes inseverability, and even in cases like this one without an inseverability clause, then I think that is, as General Mongan identified, an open invitation to advisory opinions, because you're going to grant standing on the basis of the injury caused by provision B, hold provision A unconstitutional, and then say, but it's severable, and therefore the challenger doesn't get any relief. And so I think that's the problem. So I do think if the court really thinks that that standing through inseverability is a valid theory of establishing Article III injury, that that ought to come with an analysis at the standing stage of the severability issue.
I mean, what you have said about what Congress thought in 2017 perhaps illustrates the difficulty of trying to identify anything that was thought by the majority of Congress other than what it says in a law. A lot of people, a lot of members in 2017 may well have thought that eliminating the penalty or the tax would not cause any harm and the whole act could continue to function well without it. But others who voted for it may have done so precisely because they wanted the whole thing to fall. So I don't know what we can make of what was done in 2017 along the lines that you said.
So, Your Honor, I think that question points up the wisdom of the analysis in the AAPC plurality to focus on objective indications, statutory text and context. And beyond that, I would say I don't think it would be an appropriate thing for the court to do to assume that there were members of Congress who actually acting in violation of their oath to uphold the Constitution by voting for a provision they knew to be unconstitutional in the hope it would bring the law down. I just don't think that's a premise the court ought to indulge in any case, and certainly not in this one. When applying the objective factors, what we know is that Congress zeroed out the tax penalty, which is a very strong textual signal that Congress did not think that the 5000A sub A needed to, what was necessary to play any significant role in maintaining these markets. And of course, the context here.
Justice Breyer, we apologize for the audio difficulties, and we'll go back to you.
Oh, that's all right. It's not a problem. Go ahead.
Justice Sotomayor?
Counsel, am I assuming your answer to be that given a choice between, or among, because there could have been many choices, between invalidating and the entire ACA and just zeroing out the tax, that the 2017...
I'm not sure I've ever heard it pronounced ACA. I've always heard the Affordable Care Act or ACA. I'm not sure I've ever heard it pronounced as a word. ACA. All right. I'm just noting that.
Congress's choice was to just zero out the tax, correct?
Yes, that's manifest on the record, Your Honor. There were efforts to repeal the entire ACA. Those efforts failed in the Senate. They were voted down. So we know that that effort to repeal the entire ACA was voted down, and the only change made was the zeroing out the tax in 5000A.
And so if the choice is, yet again, after NFIB, declaring the individual mandate unconstitutional, if one sees it as a command, the 2017 Congress has already told us that it doesn't want the rest of the act to fall, correct?
That's certainly our position, Your Honor, and that and it just would be utterly inconsistent with everything Congress had before it, with the judgment Congress made, and with the wide announcement to the public that this amendment effectively repealed the mandate.
Counsel, there's an intuitive feeling that if the individual mandate is struck down with respect to standing in the states, that they would have less reporting cost or less enrollees in their Medicaid and CHIPS program. That's their argument about standing, correct?
That's their argument. Aside from inseverability, that's the only direct injury they claim flows from 5000.
Would you address that argument? Your co-counsel for the state seems to say there's no.
Okay, my audio just stopped for some reason. Where were we?
efforts to repeal the entire ACA, those efforts failed in the Senate. They were voted down. So we know that that effort to repeal the entire ACA was voted down, and the only change made was the zeroing out the tax in 5000A.
And so if the choice is, yet again, after NFIB, declaring the individual mandate unconstitutional, if one sees it as a command, the 2017 Congress has already told us that it doesn't want the rest of the act to fall, correct?
That's certainly our position, Your Honor, and that and it just would be utterly inconsistent with everything Congress had before it, with the judgment Congress made, and with the wide announcement to the public that this amendment effectively repealed the mandate.
Counsel, there's an intuitive feeling that if the individual mandate is struck down with respect to standing in the states, that they would have less reporting cost or less enrollees in their Medicaid and CHIPS program. That's their argument about standing, correct?
That's their argument. Aside from inseverability, that's the only direct injury they claim flows from 5,000.
Would you address that argument? Your co-counsel for the state seems to say there's no. Would you address that argument? Your co-counsel for the state seems to say there's no.
Okay, give me a second. I'll try to figure out what's going on. I have no idea what's going on other than you do, but we'll try to make it through together. Let's go back to 43.
Public that this amendment effectively repealed the mandate.
Counsel, there's an intuitive feeling that if the individual mandate is struck down with respect to standing in the states, that they would have less reporting cost. Would you address that argument? Your co-counsel for the state seems to say there's no.
Okay, the only thing I can think to do now is to close all the browsers I have, and that means also closing my YouTube browser that has the stream going. The stream will keep going. I won't be able to see your chats. But the only thing I can think to do is close all my browsers and restart the browser and see if I can pick up from that line again. So for lack of a better idea, that's what I'm going to do. So bear with us and we'll try to get there together. So I'm going to lose you guys in the chat for a second. I'll be back. This is going to take a minute. I'm going to close all my browser windows. I'm going to relaunch the YouTube browser. I'm going to relaunch OYA. Going to relaunch the thing. Get back to the right timestamp, and we'll give this another shot. So I don't know what else to do, but please bear with me. Talk amongst yourselves. We will be. I can't just play the line after it. Didn't you see me just trying to click on the line after it? Just play the line after it. Didn't you see me trying to click on the line after it? It wasn't loading. I tried that. Jeez, give me a little bit of credit. Lord. I'll be back in a second. Thanks. I'll be right back.
anyway?
Well, it's clear that I think that it doesn't overcome the strong presumption of severability because it's not an inseverability clause. Now, if the Section 18091 had said, if Section 5000A is declared unconstitutional, then 42 SC 300 GG shall be deemed inseverable. Those are the insurance protection provisions. We'd have to make an implied repeal argument. I think we'd have a strong one, but we don't need to make that because the finding is not an operative provision of law. It's just a finding. And I think what's key is that what it expresses is the 2010 Congress's view about the state of affairs that existed in 2010. As a textual matter, the provision is addressing Section 5000A as it was originally enacted in 2010. That is the insurance, the mandate to purchase insurance backed by the tax. Now, the argument that my friends on the other side are making is that the 2017 Congress must have continued to agree with that finding because it didn't repeal the finding. But the 2017 Congress couldn't possibly have agreed that a requirement backed by a tax consequence was essential to an effective market because the 2017 Congress eliminated the tax consequence. And so I think that's very direct textual proof that the 2017 Congress did not share the view of the 2010 Congress expressed in the finding. And then it comes down to the question of, well, whether you're going to strike this entire law down because the Congress didn't go back and clean up that finding. But there was no need to clean up that finding because, as I said, it's not an operative provision of law, and it expresses a predictive judgment about the circumstances that existed in 2010 and what the 2010 Congress thought would be necessary to create the market. And textually, of course, the finding talks about the requirement being essential to creating the market. And by 2017, the market had been created. It was up and running. CBO told Congress to continue to run in a perfectly reasonable way if you eliminated this penalty. So I think that remnant from the finding.
You know, I just had a thought because I saw you guys in the channel discussing like a new sub-court for the Supreme Court. But here's an idea, and I don't think there's any reason the Supreme Court couldn't do it. But this, I think maybe a good idea would be the Supreme Court takes cases that it thinks is interesting and orders en banc from the lower court if it hasn't done it already, just to see if more lawyers get the answer right. So that'd be cool as a remedy. So yeah, and then like if they still need more, then the Supreme Court of course could take it, but they could order en banc as an intermediary step on the appeal process. I mean, it would slow things down, but it would mean more judges would take another look at it, and they would know, and the courts would know the Supreme Court is about to check their homework. So they might look at it more carefully. So as an idea goes, that might be pretty good. I don't see any reason that the Supreme Court can't just do it as a matter of process. They're the Supreme Court. They have supervisory jurisdiction over the lower courts. So all they'd have to do is say, we grant certiorari, we vacate the decision below, and we vacate the decision below, and we remand it for en banc proceedings, remand it for en banc proceedings, something like that. Yeah, no, they could do that. That'd be cool. Yeah. Anyways, we'll get back to the argument.
Good morning, Mr. Verley. I'd like, if we could, just for a moment, put aside standing and put aside your remedial arguments and just focus on the merits. This court held that the mandate was a permissible exercise of the taxing authority because it produced revenue, at least some. That seems to have withered away, and we're left with the Commerce Clause and the Necessary and Proper Clause, which the court foreclosed last time around. Can you help me with that?
Sure. I think it might help for me to walk through how we see this, Your Honor. The Congress started with the court's definitive construction of the law in NFIB. That the court presumes that Congress takes this court's definitive construction as a given, unless it clearly indicates a desire to change it, and we don't think it did that. And so it starts from the premise that this is a lawful choice. It was a lawful choice between maintaining insurance or paying the tax prescribed in subsection C. And Congress, I don't think there's any doubt that Congress was acting within its powers when it amended subsection C to reduce the tax to zero. You can either think of that as inherent in the tax power or necessary and proper to it, but it has to have the ability to take that step. And so what remains is a statute that isn't operative and doesn't have any consequences for anyone. So it's effectively like a statute that's been repealed, and that's, I think, why so many in Congress and the President described it as effectively as a repeal. Now,
let's just put that aside for the moment, okay? And if we're focusing on the merits and assume the mandate is still something, it's on the books. What are the merits of that under the Commerce Clause? Why aren't you clearly foreclosed by NFIB?
Well, we're not making an argument under the Commerce Clause because of NFIB, of course. Our view is that because it's an inoperative provision at this point, that it really doesn't have any more need for an enumerated power than when Congress enacts a hortatory statute. I understand the premise of Your Honor's question is to disagree with that. I think to the extent the court thinks an enumerated power is necessary, we think it could be justified as necessary and proper to the taxing power because it leaves the framework of the taxing mechanism in place in case Congress wants to do it in the future.
Thank you,
Justice Kavanaugh.
Good morning, Mr. Verrilli. Assume standing for purposes of these questions, and on the merits, the mandate is currently structured seems difficult to justify under the taxing clause for the simple reason that it does not raise revenue, among others, so it's hard to call it a tax now. And so I think you were just indicating you can't justify it under the Commerce Clause because 5 justices in NFIB said you couldn't. Can you explain your necessary and proper argument, just so I have that? You were on that.
Yeah, it's the one we made in our brief, Your Honor. It's that the Congress has the way the law exists now. The Congress has maintained the structure that existed before the zeroing out of the tax in 2017, such that should Congress decide in the future that it needs to reimpose a tax, that it doesn't need to engage in wholesale reworking of the law, can just step back in and change the number again. And in that respect, it's not entirely different. It's not the same. I'm not saying it's the same. It's not entirely different from a tax law that Congress enacts where the tax is suspended for a number of years, and we think that suffices. But I do think, Your Honor, that what this points up, even if the court disagrees with us here, and even if the court thinks that...
I'm sorry to interrupt, Mr. Verrilli, but let's assume, just for the sake of argument, assume I don't agree with that, and then we get to severability. I tend to agree with you. This is a very straightforward case for severability under our precedents, meaning that we would excise the mandate and leave the rest of the act in place, reading our severability precedents. One of my questions is, do you think that's would have been the right result under the 2010 Act, or did that change in 2017, or how would you assess that?
Well, I thought the amicus in 2010 made very strong arguments in favor of that result, but I do think the relevant point of inquiry was what did the 2017 Congress think, and I do think with respect, what would the 2017 Congress have preferred in the language of Celia law and the AAPC opinion, and I think that the answer, the objective answer to that is quite clear, that if that the very same Congress had zeroed out the tax and therefore removed any economic incentive, any economic suasion to get insurance, couldn't possibly have thought that the provision was continued to be essential to the operation of the overall system.
Thank you.
Justice Barrett?
Mr. Verrilli, if the court construes a statute in a particular way in order to avoid a constitutional question, wouldn't Congress be free to come back and say, no, that is what we meant, and in this case, for example, we did want to rely on the commerce power? In other words, why would an avoidance construction of a statute lock Congress in?
Neither an avoidance construction nor a straightforward construction would lock Congress in, Your Honor. I agree with that, but here I think that
Yes, it's a slightly strange question, it seems to me. Like, Congress can always change the law. If Congress is upset that the Supreme Court misinterpreted the law, they can always change the law. And they can even, like, override the Supreme Court's interpretation in some respects. If the Supreme Court said, we think this language means this, and the Congress can say, nope, we think this language means this. And, Congress is controlling. And then, so the Supreme Court that tried to dodge the issue would be faced it. So, yeah, there's nothing really stopping. There's nothing stopping Congress from making it inseverable. They do occasionally pass laws that they say it's inseverable. It's not unheard of, although it's rare. So Congress could say it's unseverable. They could overrule an interpretation of the court and say, nope, this is what we really meant. Sorry, you didn't get the first time. The only thing that they can't really do is overturn their interpretation on the Constitution, but they can overturn their interpretation on a statute. That's one of the things that Congress does with its time. Quite frequently. Or at least they're supposed to. We don't like that result. We're going to change the law. That's one of the things you can do. That's fine.
But I do think the presumption applies either way. Once this court has definitively construed a statute, that is what the statute means. And the court assumes that Congress takes that meaning as a given and can rely on that construction by the court when it amends the statute. And absent clear evidence that Congress wanted to depart from the court's definitive construction, the presumption is that the definitive construction stays in place. And I do think that has to be the case here, because the only way to make sense of what Congress was doing and what, as I said, everybody involved in this process said Congress was doing was that they assumed that the choice-creating
Oh, wait, we're back. Are we back? Are we hearing me? Is this working yet? Hello? Is this working yet? Oh, good. It is working, yay. Man, I tried everything. I restarted my browsers. I restarted OBS. I had to restart everything, man. I don't know what happened there. At least as far as OBS was considered, I had a good stream, because when I saw the stream go spinny, or at least you guys complain about the stream going spinny, I looked at OBS, and OBS is like, yep, no, I'm fine. 0 dropped frames, clean bandwidth, no problem. OBS was happy. OBS wasn't reporting any problem, but it was spinny. And then I restarted the browsers and restarted the OBS. Man, we have not had these kind of problems streaming in a while. Oof. When you hit Control F5, it refreshes all the cache files for a web page tab. Noted. I will try to remember that for the future. All right, where were we? We were at the end, or coming to the end, of the former Solicitor General for the United States, who is now representing the U.S. House. So let's finish up his argument, and then we'll pause again as we get into Texas's argument.
If they had assumed the opposite and wanted to impose a command, I presume somebody would have said that, and everybody said the opposite. And of course,
a minute to wrap up, Mr. Verrilli.
Thank you. The Affordable Care Act has been the law of the land for 10 years. The healthcare sector has reshaped itself in reliance on the law. Tens of millions of Americans rely on it for health insurance that they previously couldn't afford. Millions more rely on the Act's other protections and benefits. To assume that Congress put all of that at risk when it amended the law in 2017 is to attribute to Congress a recklessness that is both without foundation in reality and jurisprudentially inappropriate. In view of all that has transpired in the past decade, the litigation before this court, the battles in Congress, the profound changes in our healthcare system, only an extraordinarily compelling reason could justify judicial invalidation of this law at this late date. Respondents' arguments in this case are anything but. They should be rejected. Thank you.
Thank you, counsel. General Hawkins?
Okay, now we've gotten to the end of the U.S. House's representatives' argument. It didn't really do anything for me, particularly one way or another, to be quite honest about it. I didn't really think much of it one way or another. It really didn't add anything to it for me one way or another in terms of any of the real issues that are here. So I don't know. I don't know if you guys got anything from the U.S. House of Representatives attorney, but for me, I mean, it was fine. It just didn't illuminate any issues or clarify anything for me. So for at least me personally, I found it to be kind of a waste of time. Oh well. Let's move on to the great state of Texas's argument. and see what they have to say. And then we'll finish up with Mr. Wall, who's arguing for the United States government, who is probably a better solicitor than this guy is. So it's ironic, I guess, isn't it? It is a bit ironic that they call them the Solicitor General, because it's I don't know how that comes to be, because in English law, or in English custom, and I think English law for that matter, solicitors are the ones who do transactional work. Barristers are the one who go to court. So it's I just realized this like just now for the first time. It's a little weird that they call them the Solicitor General, because wouldn't it be the Barrister General? But no, they call them solicitor, even though that's not really the right nomenclature, or at least it wouldn't be in the UK. I never really thought about it before. Oh well, that's where we are. In any case, let's listen to the Solicitor General from the great state of Texas, Kyle Hawkins, and see what he has to teach us. Great.
Thank you, Mr. Chief Justice, and may it please the court. This case should be resolved on the basis of three operative provisions that appear in the U.S. Code today. The first is the individual mandate, which is a command to the American people to purchase health insurance that the federal government deems suitable. The second is a penalty provision that ensures that the mandate raises no revenue for the federal government. The third is a legislative finding enshrined in the text of the law itself, declaring the mandate essential to the operation of the marketplace reforms that the ACA set out to achieve. The Obama administration's Department of Justice described that finding as a functional inseverability clause. Under NFIB versus Sebelius, the mandate as it exists today is unconstitutional. It is a naked command to purchase health insurance, and as such, it falls outside Congress's enumerated powers. And the legislative findings declaring the mandate essential require this court to conclude, as did the district court below and the joint dissent in NFIB, that the mandate is inseverable from the remainder of the law. In asking the court to hold otherwise, petitioners are really asking this court to ignore statutory provisions in the U.S. Code. Petitioners instead prefer to hypothesize about what various legislators might have been thinking when they voted to eliminate the penalty provision, yet retain the mandate and the legislative findings. But that's just an argument that this court should set aside the text of the law in favor of non-textual considerations. That gets things exactly backwards, as this court has confirmed time and again in recent years. There is no basis to ignore the words that Congress enacted and that remain operative today. The proper course is to take Congress at its word and declare the mandate unconstitutional and inseverable from the remainder of the ACA.
I just also like to take note that my stream has dropped to 188 concurrent viewers. I was at 300 viewers. I lost a third of my viewers. Thanks, YouTube. Thanks, YouTube. All right.
General Hawkins, on the severance question, I think it's hard for you to argue that Congress intended the entire act to fall if the mandate were struck down when the same Congress that lowered the penalty to zero did not even try to repeal the rest of the act. I think, frankly, that they wanted the court to do that, but that's not our job.
Well, Mr. Chief Justice, I would respectfully submit that it is this court's job to follow the text of the law as written, and I think it's critical that in 2017, Congress could have excised the legislative findings in 18091, but it chose not to do so. It could have excised...
But I mean, I certainly agree with you about our job in interpreting the statute, but under the severability question, we ask ourselves whether Congress would want the rest of the law to survive if an unconstitutional provision were severed. And here Congress left the rest of the law intact when it lowered the penalty to zero. That seems to be compelling evidence on the question.
I don't think so, Mr. Chief Justice. I think what that establishes, or at least one reasonable reading of what happened, is that Congress wanted to give the American people a tax cut. and it went through lots of provisions of the Internal Revenue Code, cutting taxes here and there, and one place it found to give the people a tax cut was in 5000 AC, but it wanted to keep that mandate in place because the mandate would still drive people to acquire insurance. And indeed, it would have been quite reasonable for Congress to conclude that simply having a mandate will lead people to sign up for health insurance. As originally enacted, the Affordable Care Act included groups of people who were subject to the mandate but exempt from the penalty, including the very poor and members of Indian tribes. And I think that's an indication that Congress believed that simply ordering people to do something would get them to do it, notwithstanding any penalty that may be attached.
General, you talked about the findings in the legislation and treat them as if they were an inseverability clause, but it doesn't look like any severability clause anywhere else in the rest of the U.S. Code to me.
Ooh.
Well, Your Honor, there's certainly no magic words requirement for a severability clause or an inseverability clause.
Ooh, I don't like that answer at all. I mean, that might be technically true, but I can't think off the top of my head, and that probably is somewhere, because severability is assumed. And sometimes you actually do explicitly mention severability. It's not uncommon to mention explicitly, but it is assumed. But I'm trying to think of any time I've seen it, but particularly it would have to be an inseverability issue. I'm trying to think of any time I've ever seen a court say that there was an inseverability because of words other than the statute shall be inseverable, except where okay. All right. So let's just back up and try to do this again. All right. So the severability issue is twofold. Can you remove a section from the statute? And if you do so, does the rest of the statute remain? So I've definitely seen courts remove parts of statutes and then say the rest of the statute can't stand on its own, so the entire thing is struck down. That happens. But I'm hard pressed to think of a time where a court has said the legislature wanted it to be inseverable because of language in a statute that said anything other than we want it to be inseverable. So it might be technically true that there's no magic words, but I'm hard pressed to think of any time where a court has said a legislature obviously wanted this to be inseverable. And though they didn't write, we want this to be inseverable, what they wrote was X, Y, Z. And by that language, they clearly meant inseverable. So I really don't like this answer at all. This does not feel like the best answer to this question on any level. It doesn't. There's no magic words for inseverability. I don't know. It usually has to be pretty explicit. All right, let's move on.
What we see in 18091 is a repeated emphasis by Congress that the mandate is essential to what they were seeking to accomplish. This is not some fleeting reference in one provision. In subsections H, I, and J, we see over and over again.
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. General Hawkins, I think we're shadow boxing a bit here. The individual mandate now has no enforcement mechanism. So it's really hard to determine exactly what the threat is of an action against you. Could you comment on that a bit and just give us an understanding of what your injury is?
Sure, Justice Thomas. So we've offered 7 different bases to conclude that the standing requirement of Article 3 is satisfied. I would submit that the easiest path to confirm standing is through the injury that the states have suffered. In particular, The CBO confirmed in 2008 and 2017 that simply requiring people to sign up for health insurance would lead people to do so. And it's reasonably likely, based on that, that people will sign up for Medicaid who otherwise would not have done so because of the command to do so. Now, General Mongan suggested that we not put on evidence of that, and I respectfully disagree. We've put on the 2008 and 2017 CBO reports, the individual affidavits themselves at pages 73, 76, and 77 confirm that individuals will sign up just based on a command to do so. And there are numerous state affidavits, including from Mississippi, Missouri, and South Dakota at 148, 154, 187, talking about costs imposed by the mandate on the states. And we see the increased Medicaid enrollment set out in, for example, page 91 of the Joint Appendix, which is a Wisconsin affidavit. Now, we would submit that under Department of Commerce versus New York, that is more than enough to conclude that there's a substantial likelihood of at least one person signing up for a state Medicaid program, which of course would cause at least $1 in injury and satisfy the standing requirement. And that's just our first of 7 theories. I'm happy to go through more if Your Honor's not satisfied.
I'd like to move to, at which stage would you determine inseverability? There's a lot of talk that we should consider this at the standing stage, but when I look at inseverability, I think of it as statutory construction and something more suitable for the merit stage. But I'd like your comment on that.
Well, Justice Thomas, we think that this court has described the severability analysis as part of the remedial analysis. And so we submit that the proper course here is to conclude that at least one plaintiff has standing for any of the reasons we put forward, and then to conclude that the mandate is unconstitutional. And upon doing so, we would submit that that's when the severability analysis comes into play.
Justice Breyer?
Thank you.
Turning to the merits, is your point, what do you say about many, many statutes, I suspect, that do have or could have statements, do this, don't do that, or do this, and they do not have any enforcement, they do not have any effect. World War I, defense statutes, buy war bonds, an environmental statute, plant a tree, one of 1,000 statutes commemorating something, Beautiful Cities Day, clean up the yard. I mean, I can recall, or I believe, just dozens and dozens of statutes where Congress says something where normally we would say it's precatory. Now, are all those statutes suddenly open to challenge? I mean, are none of them? If so, you lose. And if it's in between, which ones are and which ones aren't?
What?
So, Justice Breyer, you asked whether they're open to challenge. I guess I'd want to know what
on the merits, if you have a merits claim, can you suddenly say, this is no good because people will do it? They'll buy war bonds. They will plant a tree. At least one of them will clean up the front yard. Okay? And thereby, I don't know. You see the point. It's a merits point.
So,
Breyer says that we see the point. Okay.
Justice Breyer, I guess I'd want to look at the particular statute. We know from NFIB that the government cannot order people to enter commerce, people who are not already in commerce. And if another statute is like that, then I think NFIB would control.
You're missing the point. You're missing the point. On each of them, there is some constitutional argument that if there were a penalty attached, it would be unconstitutional. They take the penalty out from all my examples. Now, no penalty. And do you say
that they are nonetheless unconstitutional for whatever reason? If so, I think there will be an awful lot of language in an awful lot of statutes that will suddenly be the subject of court constitutional challenge.
All right, okay, let's go. All right, so let's go back up to his examples, I suppose. World War I defense statutes buy war bonds. Well, buy war bonds doesn't have a penalty attached to it. If you buy bonds, they'll give you money. But you don't have to buy them. In an environmental statute, plant a tree. Who's being commanded to plant a tree? What is this? What is this random thing? What is this? There's a law that says plant trees? What is this law that says plant trees? Is it a resolution? Is it a resolution that says it would be good to plant trees? Is it a resolution? Maybe the House and Representatives or the Senate or both, some Arbor Day, pass a resolution that says it would be good to plant trees? What? If there's a statute that's requiring someone to plant trees, presumably that person might have an interest in the planting of trees or not. Okay. And this theoretical statute that's telling someone you must plant trees, but there's no penalty if you don't. What? Okay. And one of 1,000 statutes commemorating something, which sounds suspiciously like a ceremonial resolution. We proclaim something. We proclaim it to be whatever day. It would be good for people to clean up cities. It would be good for people to clean up yards. Is there a law that says you must clean up your yard, but doesn't have a penalty to it? What? I'm confused. I think Justice Breyer broke me. I'm missing the point. All right, let's press on.
Justice Breyer, we don't dispute that inherent in the nature of sovereignty is the power for the government to speak, and so we don't challenge the idea of truly hortatory statements or Congress giving suggestions or recommendations, and if those statutes could be read that way, then that might change my answer. But what we have here, and this is, I think, the critical difference, it is not some suggestion, not some hortatory statement. It is the law of the United States of America today that you have to purchase health insurance, and not just any health insurance that the federal government has decided would be best for you. And that is certainly subject to challenge.
Thank you.
Justice Alito? General Hawkins, can I ask you, I hope, two quick questions about your theories of standing. First of all, as to increased Medicaid costs, because you are required to calculate eligibility based on modified adjusted income, what would happen if you didn't do that?
Well, we don't know for certain because we haven't tried, but I believe the federal government could bring some action against us, or somebody who should be eligible for Medicaid under the ACA, but isn't because of the way we've done the regulations, I suppose would be able to sue us.
Would there be penalties? Does the Affordable Care Act set out any penalties for failing to do that?
I don't know of a specific penalty or fine that would be levied against the state in connection with a failure to comply with the MAGI requirements. Of course, there are penalties that states can suffer in connection with IRS reporting and other things like that.
Okay, as to the reporting requirements in Section 6055 and 6056, the consequences for failure to comply with those, I believe, would be a penalty under the Internal Revenue Code, which this court has suggested is a tax for purposes of the Anti-Injunction Act. So how could that theory of standing survive the limitations imposed by the Anti-Injunction Act?
Well, the provisions in 6055 and 6056 flow from the mandate and are echoed in IRS regulations. The 2020 instructions, which were released recently, say that the states have to provide this information to the federal government about how they are covering as employers their employees. And that reporting requirement itself inflicts a pocketbook injury on the states. Those forms don't produce themselves. And our theory is that that pocketbook injury itself is enough to satisfy Article 3. I don't think that poses an AIA problem. And indeed, those injuries, as the Fifth Circuit correctly held, flow from the individual mandate itself and are traceable back to the mandate.
Thank you.
Justice Sotomayor?
Counsel, I'd like to understand that a little bit more, your last statement. As I understood the theory you explained earlier of your standing, you say that you assume some people would comply voluntarily with the legal command at issue here, the individual mandate. As I understand it, the CBO report predicted that only a small number of people would do that, the exact opposite of what it said in 2009, because of a willingness to comply with law. But you have to take it a step further. You have to prove that that small number would include people who didn't enroll for Medicaid and didn't enroll for CHIPS when it was a legal requirement as a tax, but they would do so now after they're told there's no penalty for it, there's no tax for it. At some point, common sense seems to me would say, huh?
Yeah, that's pretty good.
There's only a small number of people who would do it. That small number of people have to include Medicaid and CHIP recipients to affect you as a state at all. And they would, once they're told there's no tax, enroll now when they didn't enroll when they thought there was a tax. Does that make any sense to you?
It does make sense to me, Justice Sotomayor, under Department of Commerce versus New York. I would note that in that case as well, we were talking about a very small number of people who would unlawfully refuse to respond to the census if it included a citizenship question. And the standing theory in that case was premised on assumptions about people breaking the law. Our theory in this case is, at least in part, predicated on assumptions about people following the law.
Yeah, but the posture is a little bit different factually. That's just some Sotomayor's point, is that it doesn't quite make sense, because it's just, because the people who would not respond to the census question have responded to other census questions, presumably in the past, or would be willing to answer other questions. They just wouldn't be willing to answer this one. So they hadn't engaged in other law-breaking behavior that this would be deviating from. So the predicate isn't quite there. I think Justice Sotomayor's point is valid if it's factually right, that these people had legal obligations to buy other things, and they didn't do that when there was penalties, but now that there is no penalty, they would follow this law because the desire to follow law doesn't quite make sense. So the factual posture is not the same in both cases. So I think Justice Sotomayor has a solid point. If her factual predicate is right, it's like these people's behavior doesn't make any sense, which is basically a very fancy way of saying it's a pretext, right? It's absurd. They don't actually believe what they say they believe. So I think Justice Sotomayor, if her facts are right, she's got a good argument there. Okay.
The problem is that your theory assumes that people are going to pay a tax and break the law by not buying insurance, but they wouldn't do it when the tax is zero. That makes less sense. But moving on from that to the substance, okay? In NFIB, we said at least 4 times by my count that individuals cannot be compelled to buy health insurance under the Common Clause. They could only be asked to make a choice under the tax clause. Now, the individual plaintiffs here still believe that there's a command, contrary to what NFIB said, that they must buy health insurance. What your only remedy would be to say that provision's unconstitutional under the Commerce Clause, and it's unconstitutional under the tax clause. But I don't understand why you're entitled to greater relief when NFIB only says, it already says it's unconstitutional. We could say it's unconstitutional now, but you're arguing that somehow us saying it a second time would convince Congress that it could command you to do something we said it couldn't do. Again, does that logic make sense?
It does, Justice Sotomayor, based on the text of the law. The court, of course, in 2012 upheld...
We said in NFIB that we couldn't read the text of the law the way your clients want us to, because it would be unconstitutional.
So, Justice Sotomayor, in 3A of the Chief Justice's opinion in NFIB, that part of the opinion notes that the best reading of the individual mandate is as a command to purchase health insurance. And then in subsequent parts, 3B and 3C, the Chief Justice explained that an alternative reading was fairly possible. That's what's missing today. There is no fairly permissible alternative reading of the law. And that leaves us with the conclusion in 3A of the Chief Justice's opinion that the mandate is best read as a command to purchase health insurance, and that is unconstitutional. And the text of the law says that the remainder of the ACA cannot work without that individual mandate.
Well, that was his best answer so far. Yeah, that was his best answer so far. So yeah, Sotomayor was raking him over the coals of the heading of NFIB, and NFIB, he says, no, the way I read NFIB, it said, well, Section A said the best reading is as a mandate, but there's an alternative reading. They've gone rid of the alternative reading, so therefore, according to Chief Justice logic, the only reading left is as a command. So, Sotomayor, you're misreading the opinion. I don't know whether or not it's persuasive to anyone, but it's by far and away his best answer so far. So, good answer. I don't know whether or not anyone will buy it, but good answer.
Justice Kagan?
Yes, Mr. Hawkins, continuing on the merits, I'm not sure I understand the position. In NFIB, we held that the ACA was not an unconstitutional command. So I would think that has to be the starting point. Now, since then, there has been this change, and in this change, where Congress reduces the penalty to 0, Congress has made the law less coercive. So how does it make sense to say that what was not an unconstitutional command before has become an unconstitutional command now, given the far lesser degree of coercive force?
Well, Justice Kagan, I'd like to start with the premise of your question about the holding of NFIB. That holding is an alternative reading of the statute, a savings construction predicated on the fact that at the time, the individual mandate could possibly be read as glued together with the penalty provision.
Well, I think you have to, excuse me if I might interrupt, General, I think you have to accept that holding, because that holding is what allowed the ACA to remain in existence all this time. I mean, so however it was that it was 4+1 and what exactly that one said, the holding of the court was that the ACA was not an unconstitutional command.
And we would submit this court is not bound by that holding today because the underlying predicate of that holding is no longer in the United States Code today.
His answer here is a good answer. So again, whether or not you buy this, but it makes sense. Like there's a change in the predicate, So the conclusion no longer flows. It's a good answer. Whether or not you believe it or not, it's a good answer. Good response.
Well, the only thing that's changed is something that made the law less coercive, is what I'm suggesting.
Well, Your Honor,
if you make a law less coercive, how does it become more of a command?
Well, Your Honor, the law was always best read as a command, as 3A of the Chief Justice's opinion makes.
You're just disputing the premise of what we held in NFIB, which has, which I don't think you can dispute. But let me go on.
Yeah, so this is this dispute over what NFIB did or did not hold, which there's lots of articles on this. So this is not like just an Eligibility Kagan versus Hawkins thing. This has been a dispute. This is what the lawyers talk about, in our parties because we're lame. These kind of things about whether or not it was a command or not, or how best to read NFIB. Law reviews and talks are given over this stuff. So yeah, it wasn't just her and him fighting this out. But yeah, I think his argument makes sense. It's not exactly that he's disputing the premise of NFIB. It's that NFIB is built on a premise that no longer exists. So he's not disputing the premise of NFIB. He's disputing that premise continues to exist. That would be the right way to phrase it. So he's not disputing the premise of NFIB. He's disputing the premise continues to exist. He says, Chief Justice Roberts' opinion says, it's best read as a mandate to buy. It's best read as an imposition. And also here's an alternative reading based on this tax thing. And that tax thing has been taken away. So logically, if there's one of two readings and the Supreme Court picked one reading, and logically, if Congress eliminated that reading, then the only thing that would be left would be the first reading, right? Because Justice Roberts says, well, you can read it one of two ways, option A, option B. So if Congress said not option B, then the only way left is A. And he is saying that Congress did that. He's saying Congress said not B. And so it's not that he's disputing the premise of NFIB, which was but B, though. He's not disputing that. He's disputing that B continues to exist, and therefore only A. So I'm not sure if they're talking past each other, but yeah, this has been a bit of a dispute. But I think his argument makes sense. Again, whether or not you buy it or not, exactly what this is like. This again, this is the kind of thing that lawyers deal with in their time at cocktail parties. This like really fine minutia crap that then everyone who's not a lawyer looks at all the lawyers funny because we start arguing over this like really pedantic minutia stuff. But then again, that's of course our trade is really pedantic minutia. So arguing over exactly what was said in the ACEA and exactly what Congress did and exactly what that does and blah, blah, blah. Fun times, but that's why I'm here, to try to unpack it all a little bit. But yeah, good times. Let's press on.
So 5000 AE says that a class of people, and these are mostly poor people, who were subject to the mandate, but have those people are subject to the mandate but have never had to pay anything. So do you think that in NFIB, what we really should have concluded was that those people were subject to a command, whereas everyone else had a lawful choice?
So I think that those people, the very poor and members of Indian tribes, I think that if at any point they had brought an as-applied challenge, I think they would have been entitled to prevail because Your Honor is correct. From day one, Congress has been ordering them to do something which is beyond Congress's commerce power.
I mean, doesn't it seem exactly backwards, General, to say that those people who never had to pay a thing were subject to a command when people who did have to pay, who felt the coercive power of government, were not subject to a command?
Your Honor, that is Part 3A of the Chief Justice's opinion in NFIB, indicating that the mandate is best read as a command. Now, to some people, to many people, a savings construction was available at the time, but in 2017, Congress effectively took these subsection E exemptions and expanded them to everybody. And the result is that there is no tax savings construction now available, and we're just left with a command.
Thank you, General.
Yeah, that's a very good argument, very sharp argument. And it gets into exactly what did the ACA, what did the Obamacare case say, what did NFIB say, exactly what did Congress say, exactly what is going on here. But it's a very good argument. And he argued it very well to someone who was very hostile with him. He did it with respect. He did it with care. He didn't get flustered. He didn't get angry. He just stayed on point, and he responded to the questions in a very sort of equal way. So this is the kind of advocacy I like. I like this. This is the kind of advocacy I like, when it's very even, very controlled. It's very respectful. You're answering the questions, and you're dealing with someone who's extremely hostile to you, and you're dealing with it in a very sort of collegial way. And I've commented before on this channel when we've heard this before from both men and women who do this. And I thought this was a good example of advocacy. So whether or not he'll win in the end, I really liked his style. I liked his way that he addressed this issue. And, Justice Kagan may have a different reading than he does. And of course, Justice Kagan's reading is going to be way more controlling than his. But his argument is lucid, it's cohesive, it's coherent, it makes sense. It flows from the premises, it flows from a fair reading of NFIB, flows from a fair reading of what Congress did. And maybe another reading is better, but his argument made sense and he defended it well. Good job. Good job.
Justice Gorsuch?
Well, I'd like to pick up on that, on the merits, Mr. Hawkins, and good morning. As I understood Mr. Verrilli, his argument on the merits is that this is still necessary and proper to the taxing power, and that coercive authority is still in play. It's just that Congress has chosen to set it at 0 and wants the flexibility of retaining that provision in law because it might choose later to increase the tax again. And what do you say to that response?
I would say two things, Justice Gorsuch. Number one, this cannot be a tax because it does not raise revenue for the government and indeed cannot raise revenue for the government. In NFIB, the court noted, citing cases going back to the 1950s, that the essential feature of a tax is raising revenue. My second response, though, is that if the necessary and proper clause were to somehow save that, that would be giving Congress a police power. Everything is potentially a tax. And if Congress could justify any legislation on the grounds that, well, maybe one day we'll impose a tax, there would be no functional limit on Article I power.
Let me turn to the remedial question here, and if you could address it with respect to the individual plaintiffs. They've asked for declaratory and injunctive relief. I guess I'm a little unclear who exactly they want me to enjoin and what exactly they want me to enjoin them from doing.
So the declaration, which was count 1, on which the district court has entered partial final judgment, was a declaration that the mandate is unconstitutional and inseverable from the remainder of the act. The defendants include the United States, HHS, the IRS, and their respective commissioners, and so the judgment would be a declaration that the defendants cannot. Would be a declaration that the individual mandate is unlawful and inseverable from the remainder of the act.
What do we do about the fact that usually declaratory judgments in aid of pre-existing remedial jurisdiction, we normally require some proof that we can remedy a plaintiff's injury more concretely than just a mere declaratory judgment?
Well, here I think that
we have to show that there would be an injunction that would be available, and this is essentially an anticipatory action.
So two things, Justice Gorsuch. Number one, the United States in district court insisted that an injunction would not be necessary and that it would treat the declaration as an injunction, and we took them at their word. Second, if that's not good enough, count 5 in our complaint is still pending in district court, and that is our request for injunctive relief. And that's still a live issue before the district court, and we can pursue that remedy if necessary.
Thank you, counsel.
Justice Kavanaugh?
Good morning, General Hawkins. Assume for purposes of my questions that there is standing, just assume that. On the merits of the mandate, before we get to severability, I want to follow up briefly on Justice Breyer's questions, because my understanding might be a little different from his about the existence of other laws. I think when I asked General Mongan, he agreed with me that there are no examples in the U.S. Code that he's aware of where Congress has enacted a true mandate to do something to purchase a good or service, not something hortatory, but a true mandate with no penalties. Is that right?
I think it is, Justice Kavanaugh. I can't think of anything, and it would make sense that that were correct because the Affordable Care Act, of course, was an unprecedented statute. I believe that Congress had never tried to do before what it did here.
Right, with or without penalties, right?
I believe that's correct.
Then on severability, if the mandate can't be justified or the mandate is currently structured, I'm using the term mandate. I understand the arguments from the other side about that term, but the mandate is currently structured, can't be justified under the commerce or taxing or necessary and proper clauses. We get to severability. And looking at our severability precedents, it does seem fairly clear that the proper remedy would be to sever the mandate provision and leave the rest of the act in place, the provisions regarding pre-existing conditions and the rest. So the question to you, obviously, is how do you get around those precedents on severability, which seem on point here?
Justice Kavanaugh, I get around them by relying on the text of the statute. AAPC, Your Honor's plurality opinion for the court, recognized that non-severability clauses can be statements of congressional intent. And as I noted earlier, the Obama administration's Department of Justice referred to 18091 as a functional inseverability clause. In that statute, we've got multiple instances of Congress insisting.
I'm sorry to interrupt, but inseverability clauses usually are very clear, and we did indicate what they look like in AAPC, and we cited an example of what they look like. And, you know, Congress knows how to write an inseverability clause, and that is not the language that they chose here. So I agree with you about focusing on the text, very much agree with that, but I just having trouble seeing that as the equivalent of an inseverability clause.
Justice Kavanaugh, we would respectfully submit that that would elevate form over substance. In subpart H, we see the mandate is essential to the larger regulation of economic activity. In subsection I, it's essential to creating effective health insurance markets. And the same thing again in subsection J. This is Congress saying over and over again that the mandate is essential to the operation of the law. And I don't believe there's any serious argument that Congress would have enacted the ACA in 2010 but for the individual mandate or without the individual mandate.
Well, they did something to that effect in 2017, however.
Well, in 2017, they gave the American people a tax cut, but they wanted, evidently, to continue ordering people to acquire health insurance, and they left in place the finding saying that that requirement is essential. And it's worth...
Don't you think in 2017... do you read Congress as having wanted to preserve protection for coverage for people with pre-existing conditions? Because it sure seems that way from the record and the text.
Well, Your Honor, we would submit that the best approach is to just look at what's in the United States Code rather than get into the game of what different legislators might have been thinking and saying in speeches and all that. And indeed, Congress certainly could have excised these findings. We've seen Congress amend legislative findings before in cases like Lopez, where Congress amended its findings in response to this court's grant of certiorari. It's telling that Congress didn't do that here, and it's telling also...
Thank you.
Justice Barrett?
Good morning, General Hawkins. I want to go back to Justice Gorsuch's questions about standing for the individual plaintiffs. So let's say that we agree with you that the mandate, by making them feel legal compulsion to purchase insurance, has caused them a pocketbook injury. Why is that traceable to the defendants that the individuals have actually sued here? I mean, I can see how it's caused by or traceable to the mandate itself, but how is it traceable, say, to the IRS or to HHS? Why is it their action that's actually inflicting the injury?
Well, so Justice Barrett, we have sued 5 defendants, including the United States, and this court has applied a long-standing presumption that the federal government acts in good faith. And by suing the 5 defendants who we have sued here, I think that's the best way of ensuring that the individual plaintiffs' injuries from the individual mandate and the other parts of the ACA that interact with the individual mandate will be fully remedied.
But doesn't it really seem that Congress is the one who's injured the individual plaintiffs here, and you can't sue Congress and say, hey, you've put us under this mandate that's forcing us to buy insurance and that's harming us, right?
Well, we've sued the United States. It is the United States' law that the individual plaintiffs have to acquire health insurance that the United States thinks is good for them.
Let me switch gears a minute and talk about state standing. There's some confusion, or I mean, it's my confusion based on differing positions taken in the briefs about these 1095B and C statements. So the House, at page 31 of its brief, says that the states would have to issue them regardless whether the mandate is intact in the statute or not. But the states point to the cost of producing these, these forms and mailing them out as part of what's created their pocketbook injury. Who's right?
So they are correct, Justice Barrett, that 6055 and 6056 are independently on the books. But if this court were to apply the longstanding presumption that the federal government will operate in good faith and respect this court's judgments, then it is reasonably likely that a declaration from this court that the mandate is unlawful would prompt the federal government to in any way reduce the administrative burden that that paperwork causes, including going through and saying who had what kind of coverage during which month. So I think that's enough to satisfy traceability and redressability, as the Fifth Circuit correctly concluded.
Okay, thank you, counsel.
General Hawkins?
So I did the Control F5 thing, by the way, and it's still not loading. So you know how you said like Control F5 will do it and so you won't have to restart your browser? Yeah, no.
I want to go back to Justice Gorsuch's question.
It's not loading. Control F5 did not work. Control F5 did not work. Let's restart the browsers and we'll start over again. I'm going to close all the browsers. Means I'm going to lose the YouTube chat. Blah, blah, blah. You know the drill. I'll see you in a minute. My stress level is pretty real right now. You know what I like? I like it when things work. That's kind of like what I like. I like it when things work. Where the hell were we?
Millions more rely on the Act's other protections and benefits. To assume that Congress put all of that at risk when it amended the law in 2017 is to attribute to Congress a recklessness that is both without foundation in reality and jurisprudentially inappropriate. In view of all that has transpired in the past decade, the litigation before this court, the battles in Congress, the profound changes in our healthcare system, only an extraordinarily compelling reason could justify judicial invalidation of this law at this late date. Respondents' arguments in this case are anything but. They should be rejected. Thank you.
Thank you, counsel. General Hawkins.
Thank you, Mr. Chief Justice, and may it please the court. This case should be resolved on the basis of three operative provisions that appear in the U.S. Code today. The first is the individual mandate, which is a command to the American people to purchase health insurance that the federal government deems suitable. The second is a penalty provision that ensures that the mandate raises no revenue for the federal government. The third is a legislative finding enshrined in the text of the law itself, declaring the mandate essential to the operation of the marketplace reforms that the ACA set out to achieve. The Obama administration Thank you.
Thank you, counsel. General Wall.
Mr. Chief Justice, and may it please the court, this case pushes at the line between faithfully following what Congress actually does rather than what it may have intended to do. When Congress eliminated the shared responsibility payment, it left standing what is now a naked command to obtain insurance, and it left standing the finding that that mandate is essential to the operation of other parts of the Act. Those choices have legal consequences, whether or not the members of Congress who voted for the TCJA foresaw them. That's how this court normally approaches interpreting statutes, and it's how this court should approach the ACA here. I welcome the court's questions.
General, your theory of standing is that a person who's not actually injured by part of the law can challenge that part of the law and through that try to strike down other parts of the law that do challenge him or that do injure him. I think that really expands standing dramatically. I mean, just in this act alone, you're talking about almost 1,000 pages, and you're letting somebody not injured by the provision that he's challenging sort of roam around through those 1,000 pages and pick out whichever ones he wants to attack.
I think the reason there isn't a floodgates problem or a sort of massive loophole, Mr. Chief Justice, and the reason we haven't seen claims like Alaska Airlines is because on the merits, it's just very rare that you're going to have this sort of textual evidence that overcomes the presumption of inseverability. And so these claims go out on a motion to dismiss if they're ever brought at all. But the theory, and Justice Alito was pressing this with Mr. Verrilli, I think, is, you know, if you imagine a statute that had a clearly racially discriminatory provision and an express inseverability clause, I think the theory of the other side is that plaintiffs regulated by that statute couldn't challenge it. And that doesn't seem right to us. The plaintiffs here have an Article III injury. They want certain kinds of insurance plans.
No, but it's a common feature. It's a common feature of standing that the result is people can't challenge provisions. I mean, it's an important doctrine. It is the only reason we have the authority to interpret the Constitution is because we have the responsibility of deciding actual cases, and that's what standing filters out.
I agree with all of that, Mr. Chief Justice. The plaintiffs here, and this is in the amended complaint at paragraph 46, and then in their declarations that appear at pages 71 to 78 of the JA, they say that they're injured because they want plans that they had before the ACA and that they cannot obtain now, but for the ACA's insurance reform provisions. That's a straightforward Article III injury under this court.
Thank you, counsel. Justice Thomas?
Yes, thank you, Mr. Chief Justice. General Wall, I'd like you to discuss at what stage we should confront the inseverability issue. There's much talk that we should do
government's view is yours, Justice Thomas. The other side, my friends on the other side keep referring to standing through inseverability. That's not right. Those two are distinct things. The plaintiffs here want insurance plans that they cannot get, that they used to have, but for the ACA. That's an Article 3 injury. It is an injury, in fact, in the real world to them right now. They want different kinds of insurance. On the merits, they have arguments about why those insurance reform provisions can't be enforced against them. And their argument on the merits is that the provisions are tied as a matter of statutory interpretation to the mandate, and the mandate is unconstitutional. Now, that argument may be right or wrong on the merits, Justice Thomas, but it doesn't have anything to do with standing. As you say, it's distinct from the standing inquiry. They have an Article 3 injury, then we move to the merits and severability, and as I was trying to explain to the Chief Justice, the reason that doesn't open the floodgates is because it's just rare that the text of the statute, which we know has to be the focus under AAPC and civil law, is going to provide the kind of evidence that would allow a plaintiff to overcome the presumption of severability. It's virtually always going to be true that the provisions are severable. It just doesn't happen to be true here given the unique wording of this statute.
Thank you.
Justice Breyer.
Yes, I'm going to the merits, and I think I do have a very different understanding than Justice Kavanaugh. What I thought I heard said was that someone in the Solicitor General's office read through the entire United States Code, which must be quite a job, and discovered that there's no precatory language in the code. There is nothing in the code that says something like buy war bonds or something like plant a tree or something like clean your yard. Is that right?
Just for there's plenty of precatory language in the code.
If you say there is precatory language, precatory means in the dictionary pertaining to entreaty or supplication. Now, how is it that you know that this mandate, just by itself, without any penalty, is something more than a supplication or an entreaty?
A couple of reasons, Justice Breyer. The first is that it says shall. You shall maintain minimum coverage, not that you're encouraged to do so. And the second is that when the majority in NFIB in Part 3C turned to the statute, it looked at not just subsections A and B, as my friends on the other side say, but also C. This is at page 562. So when it's looking at the statute and adopting the saving construction, it's looking at all three provisions and saying it has this essential feature of raising revenue. That's what allows us to take something that's more naturally construed as a command and read it as a tax.
All right, so you had someone read through the entire United States Code, and you discovered that there is no precatory language in that code that uses the word shall. Is that right?
Just for, I'm not aware of any, and in all the briefs...
I didn't say you weren't aware of any. I might be have a misplaced...
Where's this idea coming from that someone said that someone read the... Where is this idea coming from that someone said that someone read the entire U.S. Code? What the hell is this? What I thought I heard someone say was that someone in Solicitor General's office read through the entire U.S. Code. Who said that? No one said that. No one said that. Ever. I mean, the last time someone read through the entire U.S. Code is probably when, the first Congress met and the entire U.S. Code was the first bill that they wrote. That was probably the last time someone wrote through the entire U.S. Code, when it was one thing. And the idea that someone claimed to have read through the entire U.S. Code, where is this coming from? And we're basing a whole series of questions on this predicate, like there's someone out there who says they've read through the entire U.S. Code. What the hell is this? And we're basing a series of questions on this. Well, I heard a rumor that someone in Solicitor General's office said they read through the entire U.S. Code. Man, Jesus. No one said that. No one has ever said that ever. Why are we basing several questions on this hypothesis? Holy God. Jesus. Okay.
lots of things like National Port Week and all kinds of stuff that was precatory, or said, let's have a celebration, or the nation shall, but plant a tree, etc. But you have read through the U.S. Code, or someone in your office, and has learned that there is no word shall in a precatory phrase?
Justice Breyer, I cannot vouch that I have read the entire United States Code.
I haven't either. I tell you, I haven't either.
But we have looked at this question, and all of the precatory provisions to which anyone has pointed or of which we are aware say things like should, not you shall do these things. So I'm not aware of statutes that say you shall by...
Between shall and should. Okay. Thank you.
What? Okay. So many things. Just so many things. Okay. First of all, there's a pretty substantial difference between should and shall. I know those words kind of sound similar, but they have radically different meanings. Should and shall. Okay. And what the Solicitor General just said is not so much that we read through the entire U.S. Code, but, we looked as best we can, and we looked to everyone that anyone has ever pointed out, and we read those. So we read all the ones that anyone ever pointed out, and we kind of tried to do our own research, and we read those too. And we haven't found any examples of this. And where we have, they said should rather than shall. And just as Breyer says, so the difference is between should and shall? Yes? Those are kind of different. Should, shall. We just wasted an entire sequence of questions on. So what you're saying is someone read the entire U.S. Code. It's Kathy Newman over here. Kathy Newman. So what you're saying is someone read the entire U.S. Code. No one is saying that. Literally none of the people are saying that, like, ever. What they are saying is that they looked at anyone has ever cited, and they tried to look as best they could, and they couldn't find any. And to the extent they did, they said should. And Justice Breyer's over here with like, oh, so you're saying there's a difference between should and shall? Well, that was a useful use of all of our time collectively. That entire exchange was a wonderful use of our time, where we got to learn this heated exchange over whether or not someone claimed to have read the U.S. Code, and then we learned that should and shall mean different things. Well, that was a good use of all of our time. Wow. Just wow. Okay.
I think that's one key distinction, Justice Breyer. I would also point to not just the passage in NFIB, but the exemptions. There are exemptions from the mandate for people with religious exemptions and prisoners and illegal aliens. And if it really is just a choice conferring provision, as the other side says, a choice you would have anyway, just by virtue of existing, it's hard then to explain what the exemptions to that mandate do.
Well, as you say that, it reminds me in English, have I ever said, or have you ever said to someone in your family, you shall do it, but that is an entreaty. An entreaty, or a supplication, rather than threatening a punishment. Have you ever heard that word used, shall, in respect to a supplication or an entreaty?
No, Justice Breyer. In my family, when I tell my kids that they shall do things, that's a command backed by a penalty.
Well, that's a much more organized family than mine.
What the fuck was that? What the hell was up with that tone of voice? Jesus Christ. What was up with that tone of voice? Holy God. What is up with that tone of voice? Jesus Lord.
Well, that's a much more organized family than mine.
What? What? What is with this tone of voice? This tone is so completely dismissive and ridiculing and doubtful It's doubtful and ridiculing for the bombshell proposition that there are parents out there that if they tell their kids they shall do something, they're willing to back it up with some kind of penalty. Apparently, this concept is beyond the pale and worthy of ridicule. Wow. That was so dismissive. Man. What is Justice Pryor's problem today? Lord. I've never heard him get this personal. And the entire stuff dealing with you're claiming someone read the U.S. Code just seems so personal. Because there's no way that there's anyone who claimed anything even remotely resembling that. So the entire question doesn't make sense. I overheard someone say they read the entire U.S. Code. No, you didn't. No one has ever said that in the history of ever. That would be one hell of a claim. And you base all these questions off this, and you're saying, it's a personal thing. Like you made this outrageous claim that no one would even make ever because it's completely outrageous. And then this guy says, have you ever heard someone say shall in a family and not mean it? Well, when we use shall, we kind of mean it. Well, your family is much more organized than mine. What the hell is this?
Justice Alito?
Perhaps there's a difference between a supplication and a tax. Are you aware of any provisions in the code in which Congress has purported to use its taxing power to say, you must do this? We're going to tax it, and we're going to set the tax at zero.
No, Justice Alito.
The feature of this case that has a strange aspect is the sea change that's occurred in the understanding of the role of the individual mandate between our first Affordable Care Act case and today. At the time of the first case, there was strong reason to believe that the individual mandate was like a part in an airplane that was essential to keep the plane flying, so that if that part was taken out, the plane would crash. But now, the part has been taken out, and the plane has not crashed. So if we were to decide this case the way you advocate, how would we explain why the individual mandate in its present form is essential to the operation of the Act?
I think a couple of things, Justice Alito. Yes, our basic position is that the findings are the functional equivalent of a targeted inseverability clause. The government said that back in an FIB. If the court, the joint dissenters, agreed with that, I think, and if the court had invalidated the mandate, I think there's good reason to believe that the court would have and should have also invalidated with it guaranteed issue and community rating, because that was the most natural way to read the finding. And if that was the most natural way to read that finding, its text, before 2017, it's still the most natural reading. Nothing about the text of 2017 changed. Congress did a very targeted thing in 2017. It said we don't want people to have to make this payment anymore if they don't want to get insurance. And yes, that was less coercive in a sense, as Justice Kagan pointed out, but more coercive in another, which is now it's just a naked command, and they didn't disturb the finding. And I take the point on the other side that if you look at all these things from CBO reports to statement of legislators, that you can divine in the collective consciousness of Congress a judgment that the finding is no longer correct, but they didn't amend or alter the text of the Act.
Thank you, General.
Justice Sotomayor?
Counsel, do you concede that Congress has the authority to enact taxes with delayed start dates?
Yes.
Okay. Can Congress also enact taxes that phase out some years in the future? 10% this year, 8% next year, going down by 2 until 5 years from now. Can Congress do that?
Absolutely.
And, okay, so that you agree that if in 2020 Congress had enacted the share responsibility payment, the tax, to phase in 2014 and phase out in 2009, that would have been permissible, correct?
Yes, I think
All
it
right,
would.
let me finish, counsel. If Congress had, in the TCJA, provided that the shared responsibility payment would be zero in 2019 and 2020 and 2021, but would phase back in as of 2022, would that be constitutional?
Well, it depends a little bit what you mean by the question, Sotomayor. It depends a little bit what you mean by the question. Like in the abstract, Congress can have a tax that goes back to zero and then changes at different times. That's true. But if you're using the tax as the underpinning for the constitutionality of the statute, then I'd have to say no. If it goes down to zero, then even if it's going to ramp up later, then it becomes unconstitutional for that period. Like, constitutionality or an unconstitutionality can change. This was my point in today's video dealing with the Colorado COVID cases, where I thought it wasn't as well written as Stickman's opinion, but it more closely tracked my legal thinking than Stickman. So I like Stickman's thinking better, but Stickman is smarter than me. So the district judge from Colorado, in his case, his thinking was closer to mine, although it wasn't as well written, which might say something for my own talent or lack thereof, but that's okay. Stickman is allowed to be smarter than me. He's pretty smart guy, so we can definitely have judges be smarter than me. That's okay. Anyways, so this was kind of the district court in Colorado's point. Like, things become constitutional or unconstitutional change with circumstances that change. As facts change, they can be unconstitutional one day and constitutional another day, depending on variables. So the idea that just because something is constitutional yesterday and just because it's constitutional tomorrow, that's necessarily constitutional today, doesn't necessarily flow. It's possible, because you'd have to evaluate it separately. Something can become unconstitutional one moment and be constitutional next, depending on the situation. And so if Sotomayor's question here is, if this tax was zeroed out for like 3 years, would the ACA still have the backing? Then my answer would be no. It would be unconstitutional for those 3 years, and then presumably it would be constitutional again in 3 years, but it wouldn't be constitutional now, but it'd be constitutional in 3 years. So it would have been constitutional in the past. It's not constitutional for 3 years, and it would be constitutional 3 years from now, because the underpinning has changed. And so, like, if that's Sotomayor's question, then my answer would be no, it's not constitutional for that 3-year interim. It would be constitutional in year 4 because the factual pinning has changed. At least according to NFIB, it'd be constitutional, because then you're back just to NFIB at that point. So if I'm relying on NFIB, it'd be constitutional. But if Sotomayor is trying to say, like, it's okay for there to be this lapse and it's still like ride through on its constitutionality, I'm not really seeing that one. No.
I want to say one thing, Justice Sotomayor, which is I believe it would, but I think all of that would have been evidence before the court in NFIB why you wouldn't read it as a tax, because if you were sort of phasing it out, it would look more like a penalty that you were graduating down.
But all that Congress did, answer the question to my last hypothetical. If Congress had, in the TCJA, provided that the shared responsibility would be zero for the first 3 years, but would start off at a certain percentage in 2022, would that be constitutional?
If they had just delayed the payment of the shared responsibility payment, Justice Sotomayor, yes. I believe that.
So what's the difference between that and a decision often made by Congress that for a certain number of years, whatever fines, penalties, taxes were due from people, they're not going to collect? We've had cases with that where I think we had a case just last year where Congress was going to pay a bonus to soldiers and suspended that bonus for 3 years and then reapplied it later. What's the difference between that constitutionally? If Congress has the power constitutionally to delay, to extinguish, to restart, why is this any different that at least 2 Congresses have chosen to forego the tax, but another Congress has the power not to.
Yeah, no, I don't really like this question from Sotomayor, and I don't buy the analogy either, because the thing that is different in those situations is you're not using the tax itself as the legal underpinning for whatever else you're trying to do. That's what's different here, is that you're using the tax as the legal underpinning. So, for example, to the bonuses to the troops. You're not using the bonuses to the troops as the legal underpinning for anything else. I mean, you're not using the fact that you're paying these bonuses to the troops as the legal basis for like the troops existing or the troops being able to do something or something. It's not providing a rationale for further action. It's action unto itself and not providing further rationale. So can Congress take away bonuses in one year and put them next year? I mean, unless there's some other legal problem, then yes. I mean, there might be legal problems, expectations or reliance interests or some other reason it might be unconstitutional, but it wouldn't be obvious. It wouldn't be obvious for the same reason. And also, suppose that Congress just for 3 years decides not to have an income tax. They just decide, you know what, for 3 years, we're just not going to have any income tax. Big ass federal holiday, big ass federal tax holiday. Well, there's nothing that about that would be problematic, except for this statute, because this is the first time this has ever happened. But except for this statute, the fact that Congress is collecting taxes is not a legal underpinning to further action. It might be a monetary underpinning, but it's not a legal underpinning. So if Congress chooses to not have an income tax for 3 years and then chooses to institute the income tax and then chooses to take it away, put it in, or whatever, I mean, there's nothing obvious that's preventing Congress from doing that. Again, maybe some sort of reliance interest, equitable interest, some other constitutional reason, but it's not a legal underpinning for something else the government is trying to do. What makes this situation unique is the tax in question here is being used as the legal underpinning for other governmental action, which again, I don't think has ever been true, ever. This is the first time that this has ever happened, where they're trying to use the taxing authority as the legal underpinning for something else. So can Congress remove the tax? Yes, but then you lose the legal underpinning, which normally you don't have that problem in any other situation. So I don't really like this question from Sotomayor very much because it doesn't flow for me. Normally if Congress wants to spend money or not, it's fine. If Congress wants to tax or not, it's fine. Because normally those decisions aren't legal underpinnings to other things, right? So normally Congress choosing to spend money or not, or Congress choosing to have taxes or not, is not providing the rationale. But it's not true here. That's why the analogy doesn't work. So I don't really like this question very much from Sotomayor.
All of those other provisions, Justice Sotomayor, are written naturally like taxes. They say if you do a thing or you don't do a thing, you make a payment. The reason this is different is because once you eliminate the revenue-raising function, it's not naturally written like a tax, as the Chief Justice recognized. It was never most naturally thought of as a tax. What allowed it to be reasonably construed as a tax was the revenue-raising function. Once you cut that out of the statute, it no longer reads like any of those provisions that have suspended or delayed taxes. It reads very differently if you set them side by side.
Justice Kagan?
General Wall, assume for the moment that I don't really buy your standing through inseverability theory. Could you tell me what your view is about whether the states or the individual plaintiffs have standing here?
We haven't taken a position on that, Justice Kagan, because we think
I know you haven't. I know you haven't, General, but I'm asking you for one, because we have to take a position on it, and think of this as a one-justice CBSG.
That's a nice little thing there. CBFG means call for a brief from the CBSG, not FG. So call for a brief from the Solicitor General. So yeah, the Supreme Court can ask the Solicitor General for opinions. Call for a brief from the Solicitor General, CBSG. So it's a typo here. But yeah, it's like, I know you haven't taken an opinion on it, but I'm going to now, on the fly, issue a call for your brief. Please give me your opinion. I like that. That's cute.
Justice Kagan, I think Justice Barrett was asking some very difficult questions about traceability with respect to the individual respondents. With respect to the states, I think at page 22 of Texas's brief, it's pointing to reporting and administrative costs in its direct role as an employer. And I think that might be enough to get the state standing. But again, I want to emphasize the United States has not taken a position on that.
Okay, I mean, the United States is usually pretty stingy about standing law, so it did surprise me in much the way that it surprised the Chief Justice that you're coming in here with a theory which, to my mind, threatens to kind of explode standing doctrine. I mean, and I guess I want to go back to that because I wasn't sure I understood your answer to the Chief Justice. A lot of legislation now is in these huge packages. I mean, even more than the ACA that involve 1,000 different subjects. Omnibus legislation, where it's just everybody pours everything in that they can think of. And it would seem a big deal to say that if you can point to injury with respect to one provision, and you can concoct some kind of inseverability argument, then it allows you to challenge anything else in the statute. Isn't that something that the United States should be very worried about? And isn't it something that really cuts against all of our doctrine?
We would be worried about it, Justice Kagan, if we thought that the floodgates were going to open. But, Alaska Airlines was more than 30 years ago. People have been able to bring these claims for a long time. The reason they don't is that they rarely are. It's not a problem of Article 3 standing. It's not that they're not injured by these statutes.
If I could just interrupt for a second, General, I just don't think that's right. I mean, I have to say for myself, this theory was new to me, and I think it would be new to many people. And it's not so hard to construct some kind. I mean, all you have to do is to present a theory of severability. You don't have to win on your theory. And, in order to make this, under your view, a proper Article 3 claim.
Well, but of course, Justice Kagan, the court, as a matter of avoidance, can do severability before doing the merits. We don't think it should here, but normally a court would. And if the theory of inseverability were weak, as it usually is, it's very hard to overcome the presumption of severability. The claim would go out on a motion to dismiss stage, which is why you don't see the claims. I think the problem for the other side, just to drive home Justice Alito's hypothetical, is I think the other side is saying that even if you had a statute with an express inseverability provision and an obvious constitutional problem like racial discrimination, so it was obvious that the statute was a legal nullity, everyone regulated by that statute couldn't challenge it until somebody came along who was racially discriminated against. And as an Article 3 standing matter, that doesn't seem right.
Let me think about that a little bit further. The claim would go out. Let me read the question, the predicate question again. Present a theory of severability. You don't have to win your theory. You just have to, okay. The court can, as matter of avoidance, do severability before the merits. Sure, but not really before standing. But yeah, you could do severability before the merits. That would be fine. We don't think they should here, but a court would. But a court could, yeah. And the theory of inseverability were weak, as it usually is. It's very hard to overcome the presumption of severability. Yeah, that's true. The claim will go out on motion to dismiss stage, right? Which is why you don't see the claim. Yeah. I think the problem for the other side, just to drive home Justice Alito's hypothetical, is I think the other side is saying that even if you had a statute with an express inseverability provision and an obvious constitutional problem, like racial discrimination, so it was obvious the statute was a legal nullity, everyone regulated by the statute couldn't challenge it unless someone came along who was racially discriminated against. As an Article 3 standing matter, that doesn't seem right. An Article 3 matter, that doesn't seem right. Well, you could bring a facial challenge. If you were such a person, presumably, rather than just as an as-applied challenge, but you could bring it facially because it applied to you. So before any harm happened, this would impact you. You bring it as a facial challenge. But otherwise, I think that, you'd still have to be, even in a facial challenge, even in that case, you'd have to be a person who would be impacted by the discrimination. So yeah, if you're not a person who would be impacted by the discrimination for whatever reason, then you wouldn't have standing to bring that case. So I don't think that's odd from an Article 3 standing perspective. So I think I have to disagree with the Solicitor General on this one. If there was a statute that relied on racial discrimination, yes, you'd have to find somebody who was being harmed by that who would bring the lawsuit. If someone who wasn't being harmed by it brought the lawsuit, they wouldn't have standing. And he says that's weird under Article 3. I do not agree. I don't think that's really weird. No, I don't agree. Okay.
Thank you, Justice Gorsuch.
I'd like to just pick up where we left off there and understand from you your response to Justice Kagan and the concern about opening the floodgates here.
Justice Gorsuch, we just don't see the problem because it's going to be, as I was trying to say, it's going to be very hard to make out an inseverability claim that's going to get you past the motion dismiss stage, which is why we just don't see people walking in and challenging single provisions of omnibus acts because they don't have something like the textual finding here. It's rare to have an inseverability clause. It's even rarer to have a factual finding that goes to exactly the same question as you're asking when you do severability. I mean, in all of the briefs in this case, no one has pointed to any other statute like this one. So I think I understand the sort of reaction that we don't see this sort of theory very often. But again, I don't think that's a function of Article 3 standing. The plaintiffs here are injured. They want plans that they can't get. It's a function of the fact that their argument on the merits is not the type of argument that most plaintiffs, or hardly any plaintiffs, frankly, are going to be able to make plausibly.
Thank you.
Justice Kavanaugh?
Good morning, General Wall. Justice Breyer rightly points out that the U.S. Code has a lot of precatory language in it. My understanding matches his on that point. And to the extent the mandatory language here might be different and unusual, which was my question earlier, I think his question suggests, well, why not just construe this language as being similar to those precatory provisions that are strewn about the U.S. Code, which probably is both a standing and merits question, as I understood him to be asking. Can you respond to that?
Sure. A few brief things.
At this point, I would like to express regret that we did not establish a drinking game that every time someone says the word precatory, take a shot. Carrying on.
Kavanaugh, the first is, of course, the court in NFIB said that the essential feature that allowed for the saving construction was that it raised revenue. Once Congress has eliminated that, I think they cut out the basis for the saving construction, and then you have the word shall, which the Chief Justice recognized in NFIB is most naturally read as a command. It's read as a command in all of these other statutes. So I think the court would have to extend or stretch NFIB further than the court went there. And it seems
with respect to the mandate as currently structured, you make a forceful argument that it's not justified under the commerce or taxing or necessary and proper clauses, at least as construed in NFIB. But then we go to severability, and I understood your opening comments to say that the findings in the original act are, in essence, the equivalent of an inseverability clause. And I just want to test that for a second. I mean, as you know, we have a strong background presumption of severability, which reflects a long-standing understanding of how Congress works and our respect for Congress's legislative role under Article 1. And it also establishes a clear default rule, or fairly clear default rule, against which Congress can legislate. Congress knows how to write an inseverability clause, but this language is different from how that usually look. So I just want to give you an opportunity to respond to that.
Sure. So everyone agrees that there's no magic words requirement. And at that point, the finding speaks directly to the question here. It says the mandate, the requirement that you get into the market, is essential to guaranteed issue and community rating. And if, as the Joint Dissenter said in NFIB, once that triad is down, and as the court appointed amicus said there, it's very hard to limit it to the triad. It takes down the other pieces of the act. So I take the point, Justice Kavanaugh, that it's not written in the way one normally sees an inseverability clause, but it speaks directly to the question that the inseverability clause is meant to address, which is what is in the act that the mandate is essential to. And by its very terms, it says, and that's why I think the government argued powerfully in NFIB that it's the equivalent of a targeted inseverability clause.
Thank you.
Justice Barrett.
General Wall, the petitioners have pointed out that if, in fact, Congress zeroed this out and made it no longer a tax, they've argued that Congress would have deliberately done something unconstitutional by grounding this language, if, in fact, it has force, assume that, in its commerce power. Do you think that it's indisputable that NFIB would render such an exercise of the commerce power unconstitutional? And I'm asking because, there were 5 justices who thought that, but it wasn't a majority opinion who said it. So do you think there's room for doubt on that score?
So I do think there is a passage in Part 3C, which was joined by 5 members of the court, that does say it can't be upheld under the Commerce Clause, Justice Barrett. But even if it weren't, yes, I think it is clear from NFIB that if it is read as a command, that is not permissible under the Commerce Clause. And I don't even take any of the parties, I don't take the House or California to be disagreeing with that. They're just disagreeing on the statutory question of how best to read it. And one quick point on that to finish my answer to Justice Kavanaugh, it says shall, but I think at that point it's very difficult to make shall do the work of should. That's just more work than avoidance can do. That move would be open to the court in every case, like Lopez and Morrison. You could say, well, it just says that you shouldn't bring guns into school zones, or you shouldn't commit domestic abuse. But the court took those commands as what they were, commands that people shall do or not do something. And
well, let's assume that I agree with you and that I think shall is shall and not should, and so it's a command. But don't you think then the petitioners have a point that if, as you say, NFIB squarely would say that the mandate would be unconstitutional as an exercise of the commerce power as opposed to the taxing power, that it would be odd for us to construe the statute as Congress saying, well, we're going to change the statute in a way that's going to render it constitutional, or this provision in a way that will render it unconstitutional?
I think they have a fair point that if you were trying to define the collective consciousness of Congress, it may be that many or most of its members didn't understand the legal consequences of what it was doing because all they were doing was something more targeted. And they weren't thinking about the broader provisions or the findings or any of the rest. So I think it's fair to say that they didn't focus on this, but I don't think it's fair, Justice Barrett, to say that the court shouldn't apply the act by its terms just because that would create a constitutional problem. That's exactly what NFIB said would be the case, and that's what Congress did, whatever it may have been thinking or whatever it might have intended to do.
Thank you.
A minute to wrap up, General.
Thank you, Mr. Chief Justice. As you wrote in NFIB, quoting Chief Justice Marshall, the peculiar circumstances of the moment may render a measure more or less wise, but cannot render it more or less constitutional. As it now stands, subsection A requires every law-abiding American to obtain health insurance unless they fall within one of 3 exemptions. That broad mandate, whatever its wisdom or practical import, exceeds Congress's enumerated powers, and the court should so hold. As for what that defect means for the ACA, Congress left standing the answer it gave in enacting the ACA. And whatever one's view of the wisdom of that answer in retrospect, the court should respect Congress's answer, adhere to the text of the ACA, stay its mandate, and allow the political branches to decide how to proceed given the peculiar circumstances of this moment. Thank you.
Thank you, General. General Mongan, you have 3 minutes for rebuttal.
Thank you, Mr. Chief Justice. I have 3 points. First, if you read the text respondent's way, you have to attribute to the 2017 Congress an intent to impose the very command this court said would be unconstitutional. The court should avoid that result if there's any other possible way to read the text. And here there's an obvious alternative. If you adhere to the choice construction the court gave to 5000A and NFIB, that just makes the statute inoperative, a choice between buying insurance or doing nothing. Now, that's a somewhat unusual statute, but it aligns with this court's authoritative construction. It's exactly how Congress and the president understood the amendment and what they told their constituents they were doing. It allows Americans to freely choose whether to buy health insurance. And I think I heard at least one of my friends acknowledge that on that reading, it would be constitutional. Second, AAPC makes clear that there's a strong presumption in favor of severability that can only be overcome with some powerful objective basis. Respondents cannot identify one here. Now, this morning they pointed to the 2010 Commerce Clause findings, but those are not an inseverability clause, and they're not relevant to the severability question that's before the court today because they address the significance of a different version of 5000A backed by a multi-$100 tax consequence in the initial creation of healthcare markets. Congress zeroed out that tax long after the markets were created and after CBO told it that they would remain stable even if 5000A were repealed or made unenforceable. The text and structure that Congress created when it enacted that amendment confirm the presumption of severability because Congress made 5000A unenforceable and chose to leave every other provision in place. And the remaining provisions aren't just capable of functioning independently, they have been functioning perfectly well ever since. Finally, whatever your approach to severability, it's common ground that any remedy should respect the separation of powers and should not invalidate any more of Congress's work than is absolutely necessary. Now, what's before the court today is an enormously consequential statute. It provides health insurance and other life-saving benefits and protections to hundreds of millions of Americans. Now, there's no doubt that it's been controversial, and in 2017, Congress debated whether to keep it. But Congress ultimately chose to preserve every provision while zeroing out the tax in 5000A. If that surgical amendment created a constitutional problem, there's only one remedy that would respect congressional intent, and that's an order declaring that provision and only that provision unenforceable. Thank you.
Thank you, General. The case is submitted.
Okay, cool. Cool. Okay. So that was a lot of oral argument from 4 different people. So where do I think we're standing? Well, I think that the odds that the Affordable Care Act is going to be struck down are very, very low. I don't really see the votes for that. I think kicking it on standing is logical. I think not kicking it on standing and striking down the section is logical, and that's about it. Then if someone wants to try to go after a different section of the statute to argue it's unconstitutional because there's no pinning for it, then that would be another case for another day. But I think those are the most likely results. It gets kicked on standing, or they say there is standing and they invalidate the mandate section and don't speak to anything else beyond that. If I were a betting man right now, I think kicking it for standing is the most likely. I think kicking it for standing is the most likely, and there are good jurisprudential reasons over there. I thought the Fifth Circuit made a pretty good argument on standing. I thought their argument made a lot of sense, but I definitely can see this going the other way, and I think the tenor from the bench suggests that they want this to go the other way. So, Vidian says, you used to Nick interrupting every 5 seconds. Yeah, well, I don't know if Nick would interrupt the Supreme Court every 5 seconds or not, but yeah, it's the U.S. Supreme Court, so we only comment, when we need to comment, and otherwise we listen and we appreciate what's being said. And we also comment about Breyer and his questions, and about other things. But yeah, it was good. So I think the odds are it will get kicked on standing. I would imagine you're looking at a vote of about probably 7-2, maybe. I don't know where Amy Coney Barrett is going to be. If I had to guess, if I were a betting man, I bet that Amy Coney Barrett doesn't write an opinion on this one. She probably just joins the majority without saying anything more. So she'll probably be, if I had to guess, and I could be obviously very wrong, but I don't think she wants to stick her nose out this early, right away. I don't think she wants to stick her nose out when there's no particular reason to. So I think someone writes the opinion, probably someone other than Roberts, if I had to guess. Who writes the opinion? Not Barrett. She can't deal with that. Well, that would be interesting, though, if she wrote the majority opinion upholding it. That'd be really interesting. So maybe Barrett writes it. I could see that happening. Barrett writes a majority opinion for a 7-2 court. That'd be cool. Incidentally, in case you're wondering how assignments may happen for who gets what opinion, in case you're wondering, the most senior member of the majority gets to assign the majority opinion. And so if Roberts is in the majority, which I'm expecting him to be, then Roberts gets to decide which member of the majority writes the majority opinion. And I don't think he assigns this one to himself, because he had all that criticism over the other one. If Barrett is in the majority, maybe he gets Barrett to write the majority so that the Democrats will lose their mind or something because they actually upheld it. That'd be hilarious. So maybe Barrett writes the majority. It's a big opinion though for her. It's a big opinion for her. Usually the first opinion for a justice, for a new justice, is something really uncontroversial and usually unanimous. So usually it's a very uncontroversial, there's no dissents, there's no concurring, there's one majority opinion and it's unanimous. That's usually, and that doesn't necessarily mean this will be the first issued opinion. This could be delayed. So Barrett might get something else too, because normally the first one is a gimme to warm you up or something. Whatever. Anyways, but maybe Barrett gets the opinion. That'd be hilarious. If not Barrett, then who's most likely? I think you want to be someone on the right side of the bench. So maybe Alito, if he's in the majority. That would be good. Or Thomas, maybe, if he's in the majority. Especially if it goes on standing, I could see him being in the majority. That might be interesting. Thomas being in the majority. So yeah, I think probably in dissent. Who do you have in dissent? Maybe Kavanaugh in dissent. Maybe someone else joins him over there in dissent. Sotomayor is in the majority. I think that's pretty easy. Roberts is in the majority. Sotomayor is in the majority. Kagan's in the majority. I think Barrett's in the majority. I think Breyer's in the majority. Maybe Alito, maybe Thomas. Yeah, maybe Kavanaugh in dissent. I don't know if it gets kicked on standing. I could see it being unanimous too. If it's unanimous, then I can see Barrett definitely writing it. So that's where I think this is going. We're gonna kick it on standing, or we're gonna sever it and then say, okay, well, it's severed and you no longer have a complaint and go away. And wait for someone else to bring another lawsuit another day, and that's definitely not a problem today. But yeah. Yeah, it depends who's in the minority. Yeah, so someone said if Roberts is in the minority, it would be Thomas. Well, it depends. Who's the most senior person in the majority? So, hypothetically, it could be who's the fifth most senior person? That would be so if Roberts, Thomas, Breyer, and Alito are all in dissent, then it would be Sotomayor would be issuing the opinion on behalf of the majority, because she would be the most senior at that point. So it depends who's in the majority. But yeah, Roberts is, of course, most definitionally the most senior. So. Gorsuch. I think Gorsuch is in the majority. 8190. Written by Barrett. I could definitely see it. Yeah, I could definitely see it. Yeah, Sotomayor is the fifth most senior. So there you go. Yeah. Roberts is uphold. Breyer is uphold. I think Sotomayor is uphold. Kagan's uphold. Yeah. I think the majority. I think I don't see Roberts assigning this one to himself. I don't see Roberts assigning this one to himself. Make the new girl do some work. That'd be fun. Yeah. All right. So someone asked about what the next oral arguments I'm looking at doing are. Well, I've got two, and of course we might something new might come up, but I do have two all ready to go, or at least that I'm interested in talking about. So I was looking at Brownback versus King. What a horrible name. Brownback versus King. Man, what a bad name. Who is Brownback? He's an FBI special agent who shot King. That's bad. So yeah, we're looking at that, which deals with this really interesting issue of whether or not the attempt to arrest is a violation of the Fourth Amendment. So if the police attempt to arrest you and fail, is that violation of the Fourth Amendment, or do they have to succeed? That's a pretty interesting one. And then Fulton versus City of Pennsylvania. This is dealing with a Catholic organization that places children into foster homes, and the city of Philadelphia attempted to prevent them from doing so because the Catholic organization doesn't license same-sex couples. So the question is, can the city of Pennsylvania take away the permission or license of this Catholic charity to do foster care if they discriminate on the basis of LGBT? So that gets into interesting issues of state action. So those are the two that I have highlighted as possibilities to discuss in the future. Yeah. Nothing interesting. Well, there is the most interesting election case right now is the one dealing with Pennsylvania with the ballots received after Election Day. It's a very, very technical issue, and no one in the press understands it. It's an extremely technical issue. All right. So let's talk a little bit about this one from Pennsylvania because it's a really fascinating technical issue. And I don't know how many ballots we're talking about. These would be ballots that were received after Election Day. But not necessarily. Yeah, these are ballots that would be received after Election Day in Pennsylvania. So these ballots have been set aside, and I don't think they've been counted while the courts try to figure out what to do about them. And I don't think there are that many ballots. I think someone said like it's 1,000 ballots, something like that, maybe 2,000 ballots. So it's not many ballots. So you could imagine the Supreme Court just like punting just because they can't be bothered to care, just like whatever. Just you could see them digging it, dismissing it as providently granted. Because why wrestle into the mix about why these 2,000 ballots are valid or not if it's going to have no impact on the election? So why even be bothered to care? So, but anyways, here's exactly the precise issue in this Pennsylvania case. So okay, so first thing you have to know is the U.S. Constitution says that the legislatures of the several states can choose the time, place, manner, of elections. All right. So the legislatures get to choose time, place, manners of elections. That's the first thing. That's in the Constitution. Next thing you need to know is that the Pennsylvania law says that for votes to be valid, they have to be received by Election Day. All right. So someone went to court over it, and the Pennsylvania State Supreme Court said that placing them in the mail is good enough. So they interpreted the statute to mean that placing it in the mail is within the bounds of received. And as I pointed out on my stream with Nate Brody, that isn't necessarily insane, because although the context is obviously vastly different, this would be the rule in contracts. So elections are not contracts. I'm not saying that they are, but the idea that received of is the same thing as being mailed by is a standard rule in contracts called the mailbox rule. So if you have an offer and someone is accepting by mail, the acceptance becomes valid the moment it's put in the mail, not when it's received. So the contract is valid the moment the acceptance is put in the mail. So that's a rule in contract. So the idea of interpreting this sentence says it has to be received by Election Day as including mailing that just have to be in the mail by that date is not inherently insane, but it does seem to be a stretch of the language. So now the Pennsylvania legislature is suing. Suing the state of Pennsylvania because our law has been defied, and so there is a couple problems here. The big problem is who gets the final decision on this, because normally the state Supreme Court would be the one interpreting its own state law. So the question of what does this mean? What does it mean when it says it has to be received by Election Day? What does that mean? That's a legal question. And because it's a state law, you would then presume that the state Supreme Court gets to interpret the law, because that's what the Supreme Court does. They interpret the law. And so the state Supreme Court saying, we interpret this to include mailed on that day, is what being mailed on that day, we interpret that way. Like, even if that's wrong, there's just nowhere left to appeal to, is the problem, because the state Supreme Court is the final authority of its own state law, right? Just like the U.S. Supreme Court is the final authority of federal law. It's not, what is it? We're not final because we're right. We're right because we're final. Yeah, we're not final because we're right because we're final. Yeah, so whatever we say is right because we are final. So the state Supreme Court is the final interpreter of the state law. So if the state Supreme Court says this sentence means mailed on that date, then my initial instinct would be, well, then that's that. There's nowhere left to appeal to, because the state Supreme Court is the master of state law. And the federal Supreme Court doesn't have jurisdiction to decide issues of state law. You can't appeal a state law decision from the state Supreme Court to the federal Supreme Court. The federal Supreme Court can only hear federal issues, not state issues. The state is the master of its law, not the federal government. So then the question becomes, the question for me at least, is this sentence in the Constitution that says only the legislature can determine the time, place, manner of elections, does that give enough federal hook for the U.S. Supreme Court to say the Pennsylvania Supreme Court is in clear error and therefore has defied the will of its legislature? But it's in clear error with respect to state law, which doesn't seem like that's possible, because the state Supreme Court can't be in clear error, at least in a legal sense, until they themselves overrule it. They can't be. That's what, this is going back to Wickard v. Filburn, right? So what is it? What is interstate commerce? Well, interstate commerce includes non-interstate non-commerce. Why? The U.S. Supreme Court said so in a case called Wicker v. Filburn. So, that's what that phrase means. That's what that phrase means. What interstate commerce means non-interstate non-commerce. That's what that statement means, because that's the way they've interpreted it. And so just because the state Supreme Court did something clearly erroneous, can the federal Supreme Court do anything about that? And I've given this some thought. My mind isn't made up. But in my opinion, at least where I'm sitting right now, the U.S. Supreme Court does not have jurisdiction to hear this case. This is an issue of federalism. It's an issue of state rights. It's an issue of the 9th and 10th Amendments. It's an issue of state level sovereignty versus federal level sovereignty in our complicated constitutional republic. So, yeah, I don't think this clause gives the Supreme Court enough jurisdiction, because the Supreme Court would be overturning the state as to the interpretation of its state law, and that seems like a no-no. So, no, the Supreme Court can't do that. At least I don't think they can. So I guess we'll find out if that's right or not. But that's a really technically complex case because of the separation of powers, federalism, cans of interpretation, stuff like that. Should be fascinating to watch. And the Supreme Court may not actually decide it because they might dig it, because dig, by the way, is an acronym. It means dismiss as improvidently granted. I'm not sure if I ever explained that or not. It's a way of the Supreme Court hitting the undo button. It's a way of saying we should have never heard this case. So they grant cert and then be like, oh, never mind, we dismiss it. Dismiss as improvidently granted. They call it digging it. So if I had to bet, I'd bet they dig it. And if not, my money's on, that's the interpretation of the Pennsylvania law. And, if you're unhappy about that, Pennsylvania legislators, you can always impeach the justices, presumably. So if you think that they've made a clearly erroneous decision in defiance of your authority, you can always impeach them. So there's political remedies. So there's that, but I don't think the Supreme Court can do anything. So that's kind of where I think. Yeah, Robert Jackson. That's what he said. That's right. Yeah. Isn't it a 14th Amendment violation giving mail ballots special treatment? No, I don't think so. I don't think it's an equal protection problem. I'm not seeing it. It's everyone who was received by Election Day would still be counted. It would just be saying some other people were also counted. So I don't think that infringes equal protection, or at least it's not obvious it does. So. John Dobak says nonsense. The federal election affects all of America. Just overrule the state Supreme Court and or a new vote. Yeah, John, I don't know if you're listening to any of the words that I'm explaining this in some copious amount of detail, where I'm trying to tell you about structures of federalism and trying to tell you about state Supreme Court jurisdiction and trying to tell you about federal Supreme Court jurisdiction and who can hear what cases. I don't know if you're listening to any of the words that are coming in my mouth, but I have to admit, John, it's a little bit frustrating to me as a legal educator when I spend some time trying to lay out with some care the exact legal issues and the exact legal posture and exactly what's being trying to be decided and exactly why it's being decided. And here are the issues, and here's the tension, and here's this thing. It's a little bit frustrating to me as a educator when John Dobak over here is like, nuh-uh. It's like, why do I bother sometimes? Maybe the rest of the class can learn something. I don't know, man, but it's a little bit frustrating sometimes. John Dobak asks, what about money equals speech? I've done videos on Citizens United on my channel. You can go watch them. I think it's an error to say money is speech. It's much more accurate to say money facilitates speech. I've done videos on that at some length. Yeah, the state legislature brought the suit, yes. An in-person vote doesn't get the benefit of backdated postmark. Yeah, but it's an in-person vote. Equal protection. Equal protection only requires you to treat like things like. So I think that there's probably enough difference between in-person. I mean, in-person votes also don't get the benefit of going through the mail, right? So in-person votes don't get the benefit of being mailed. So there's enough difference, it seems, between those two things to treat them differently. Equal protection only requires you to treat things that are categorically the same, similar. It doesn't require you to treat things that are in different categories. There's enough difference, it seems like, mail-in voting and to in-person voting to split that difference. But when Supreme Court uphold the extension based on reliance, that would be a factor too. The reliance interest of the parties, possibly. Yeah, that's possible too, to uphold it on reliance. That's definitely a possible ground. Is dig a consideration on the merits? It's not. Dismisses improvidently granted is like the Supreme Court never heard the case. And sometimes they get dismissed as improvidently granted after oral argument, which is always fun, right? It's like, we never heard it. We don't know what you're talking about. What case? What oral arguments? We don't know anything about any of that stuff. We never heard that case. What are you talking about? Yeah, it's like it never happened. Election law changes should never apply to the current election. The rush to implement leaves too many problems. Fair. Oh, Rakita Law's here. I'm sorry, Rakita Law is getting blocked by my bot. That's I'm gonna add Rakita as a mod so that he won't get banished by my bot. I'm sorry, Rakita. I'm sorry, Nick. I didn't mean to have my bot. So you're now a mod on my channel, so that the bot will no longer influence you. Sorry about that. Nick, I'm glad you're here. Who gets to decide what things are like to each other? I mean, that's part of the reason that judges, well, I mean, a lot of people do. Legislatures do, courts do. But yeah, I mean, equal protection applies to things that are equally. So, you have to ask, are these things similar or are they dissimilar? And it depends on, of course, on the context of what you're asking. So, like, you can't just say, like, two things are categorically different or two things are categorically the same. It depends on the context you're talking about. So two things that are in the same category with respect to one issue might not be in the same category with respect to another issue. So it depends on a whole bunch of things, but legislators are the first ones to do it. They're the ones that passed laws dealing with mail-in voting versus in-person voting. So they're the first people to do it. Then courts look at it and be like, well, is there a rationale for these things to be treated differently? Are they different or are they the same? So that's part of the process. There's nothing beyond that. Who am I, Fauci? I don't know. I just think, I don't know. Maybe it's wrong because I don't think you do anything to filter your chat, Nick. But I just think that, having all caps is bad. So, I have an all caps thing and too many caps, too many emojis thing because I think it makes the chat a little bit less pleasant. I'm trying to make it a little bit more pleasant. I know you have a little bit more free for all, but you can type your thoughts without, spamming caps all the time. Wouldn't the same logic for digging to Pennsylvania apply to Bush versus Gore? Potentially, but they decided to hear that case. Did you see that Pennsylvania wrote out the challenges to mail in an absentee ballot? I didn't see that Pennsylvania wrote out challenges. I'm not sure exactly what you're meaning there, so no, I don't think I saw what you're referring to. Opinion on Trump campaigns, various losses in election cases. Yeah, I have not to date seen anything that looks really very promising on the lawsuits. The closest one I saw was Michigan dealing with the many affidavits. I think that one might have been dismissed. I'm not 100% sure. I need to check up on that, but that was the most promising of them, where different people were saying they saw different things. But other than that, I haven't seen any that are particularly promising yet. Of course, if anything goes anywhere, we'll definitely cover it. Yeah. The thing also I was worried about, Nick, in terms of censoring, I used to have the chat on screen, and like you do, or I was playing around with it. And one of the reasons why was I was concerned that if particularly naughty words were being put into the chat and they were then on screen embedded in my video, that it might be possible that someone might flag my video for containing the offensive words now. And so I thought that YouTube might take down my video because it contained offensive words in the video, even though they weren't strictly speaking mine, but because they're on screen embedded in the video and they're typing their horrible whatever, that someone would flag it and take down my video. So I was like, it's too much exposure. So I was trying to create the bot to deal with that problem. So I don't know if you have that problem. I don't know if you're concerned about that problem or whatever, but that's one of the reasons I did what I did. They removed the ability to challenge absentee ballots and mail-in ballots from the election code of Pennsylvania back in May or something. Cool. Interesting. That's interesting. Oh, you're calling Streamlabs, Fauci. Oh, see, that's funny, yeah. Oh, incidentally, Nick, by the way, I played a lot of Dungeons and Dragons 3.5 edition way back in the day. So I know that you like Dungeons and Dragons. So incidentally, if you're ever looking for someone to play a game, let me know. I usually play a rogue because I think they're fun. Also on 3 and 3.5 edition, they got a lot of skill points. I don't know if that's true in 5th edition. I've only played a little bit of 5th edition. One of these days I should write up a wizard or something. It's been a while. Anyways. Also, if you have not already gone to Nick's channel from Recchietta Law, you should go over to Nick's channel because he has some wonderful commentary and he is interesting and provides even more uncivilized commentary than I do. He has a panache for a aggressive, somewhat unfiltered characterization of legal opinions. You might find it entertaining. I do. So, yeah. Anyways, I've been doing this for 3 hours and change with interruptions and all. If you liked this stream, if you'd be so kind as to give it a thumbs up, I would appreciate it. If you've not already been a member, if you'd hit the subscribe button, that would be great. And did you know you can become a member of the channel? It's true. For 99 cents a month, you too can become an uncivilian. And 3 things will happen. Your name will become green. You'll get access to streams that are off-brand, such as me doing Let's Plays, and you'll get access to me doing, you'll get access to my batch records. And number 3, I will like you more. So please give me 99 cents and I will like you more. It's been a pleasure. I hope you had fun. As always, I'm looking forward to even more adventures with you in the future. Until there, my friends, I've been Uncivil Law. Until there, cheers and goodbye.